Recording in progress. Recording stopped.
Good morning, members. Good morning.
Recording in progress.
Justice and Constitutional Development.
Good morning. Good morning.
The Deputy Minister, the team from the Office of the Chief Justice, led by Acting Secretary General. Today, colleagues will be taking two budget votes, which is the Office of the Chief Justice and the South African Human Rights Commission. But we said, let's start with the OCJ, then we'll immediately request the South African Human Rights Commission to log in towards the tail end of the budget vote of the OCJ. So currently on the system, we have only OCJ. So that's all. We have received an apology from Honorable Matafa. Committee Secretary, can you confirm if you received any apologies from members?
Good morning, Chair. None from my side.
No apology from your side. Someone is saying Chairperson, which one was that?
Chairperson, it's Klopper.
Mr. Klopper, yes.
I'm sorry to interject, Chairperson. Good morning. Chairperson, I did email on the 13th that I will be present in this meeting. However, I have to log off at the latest about 10:30, 11 due to another commitment, but I will be here in between.
Oh, yes, Mr. Klopper, that's correct. You even sent me an email. Sorry for that. I forgot it. Acting Secretary General, can you first introduce the team you are with in the meeting today?
Chair, procedurally, it will have to first be the executive authority.
You are a bit cutting, Minister.
I'm saying, Chair, I am here. Am I still cutting?
Yeah, we can hear you now.
Okay, good morning to you, Chair. Good morning to the Deputy Minister and to the team that is here, SG is with us. Chair, I thought procedurally it will be the Minister first and then we'll do the team that comes through. That's why I thought maybe you didn't see that I'm in the meeting.
No, I did, Minister. I even greeted you. I was saying she must just introduce the team. I was not saying she must proceed with the presentation. She must just introduce the team.
Thank you, Chair. Good morning. Good morning, Minister. Good morning, Deputy Minister, and all honourable members of the Portfolio Committee. I am joined in the boardroom by the executive team of the OCJ. It is DDG Mukhale, Corporate Services, Management Services, Ms. Mpe, our Chief Director, HR, Advocate Lamley, currently the Acting DDG, Court Administration Services, Mr. Mulefi Masilu, our Acting Chief Director, Strategy and Systems, our CFO, Ms. Paula Morapedi, the PA of the Office of the Secretary General, Mr. Mekwa, Ms. Pulani Makibi, our CIE, and our CIO, Ms. Ngubela, Ntumeni Ngubela. Thank you, Chair. We are ready to proceed.
Thank you very much, Acting SG. Minister, now you can proceed and introduce the report. Then we'll take the Acting SG and the team to deal with the nitty-gritties of the report. Then we'll after take the DM if there are issues that things must be filled up. You can proceed, Minister.
Thank you very much, Chair. Good morning to you and members. Let me first appreciate this opportunity as well to come and present before the Portfolio Committee the report, the annual performance plan of the OCJ. I think first, Chair, let me say the context here is that it's within alignment as well with the MTDP. But again, to indicate, it's important for me to take what has happened previously and some of the issues that would be coming through, and that would be mainly announcing. Just to indicate, I did retable if members and the acting SG will highlight what the challenges. There were figures that following the visit by the CJ Chief Justice to Mthatha, there was a feeling that, as you would have heard announced publicly, that there needs to be a faster rollout of the court online, and following that, the changes in the APP needed to be effected. So there will be, she will highlight the changes that we have done as she present. I think from my side, firstly, Chair, at the beginning of the year, the President, I must highlight, the President instructed us, after getting a report from the Chief Justice, to look at support for the OCJ and the entirety of Judicial. This led to a task team of ministers, led by myself, having to sit and look at the areas of concerns. The first one was around capacitation. The second one was around infrastructure and security and many others. But these are the key three areas that I want to flag. In this, Chair, you note that following last year's budget cuts, the OCJ as well was affected, and this was raised as a concern, that if you look at Parliament, Parliament was not affected in budget cuts as another arm of the state, and therefore the judiciary should not have been affected by the cuts. So it's out of those that we have now in agreement and procedural processes that we're putting in place between ourselves and National Treasury to ensure that something like this does not happen in the future. But also, leading to that, Chairperson, I must say, that's why you'd see an increase in the budget in this financial year of the OCJ. It is out of those conversations with the Minister of Finance. One is in relation to capacitation. There would have been a request for this financial year of about 271 posts to be advertised and filled. And with the agreement, that support was provided. Though, when we engage with the judiciary, we were indicated that there's more 275 posts that are critical for the judiciary to function and that are still needed. So we said our priority would be to fill these ones within this financial year and look at where we could be able to engage again Treasury if we are able to still within this financial year. But in the outer years, this has been committed that it will be looked at from Treasury, and therefore those figures, as we go ahead in the outer years, they will have to change. Second area is around infrastructure, Chair. When we looked at infrastructure development, we were able to do, because one of the things that we agreed to was to quantify the need in terms of infrastructure. This is in terms of our courts, which are needing repairs and replacement of whatever that is needed there. But secondly, in terms of our courts, which we need to build. For example, we'd hear in terms of access to courts in rural areas, but also within the townships where your magistrate courts are not coping, and therefore they are needing extra capacity in that regard. So we looked at that as well. And out of that process, then we agreed, we identified in terms of the projects, I can say, Chair, that we were within 25-26, we made a bidding through Public Works of 1.4 billion in terms of what was required. We were given 400 million in terms of infrastructure. For the MTF, the request was for 5.4 billion to respond to all the infrastructure challenges, and we were given 1.5 billion by Treasury. So these are the gaps that exist, Chair, that we are looking at, and we've committed between myself, Minister of Public Works and Minister of Finance to sit around the table and find alternatives. But the commitment is to say that we will need to look at this. Then again, on this, I forgot something in terms of that I need to report to the committee. One of the issues when I got into the portfolio was the issue that the private office of the Chief Justice was not treated the same as the private offices of other arms of the state. So we have already sorted that out with Public Service and Administration, because we currently do not have a judicial handbook. So we utilize the Ministerial handbook to support both the Chief Justice and the Deputy Chief Justice. So those offices now, in terms of regulations or in terms of MPSA, we have been given an allowance to say the two offices in the judiciary will be able to fill the vacancies in the private office in the manner that we do in the executive and in the legislature, for example, the Speaker's office and the President's office, the Deputy and the Ministers. So we've been able to respond to that, and is currently being implemented now. Once the Deputy Chief Justice is appointed, the Deputy Chief Justice will do the same, and it will follow the same. So the people who are working for them in those offices, the agreement is that their term of office will be linked to their principals. So the same way as it's done. So that we had to rectify in this financial year. So it's another change that I thought I should flag on, Chairperson. On the security matters, one, we looked at the issue in terms of security of judicial officers, because it's not only at the courts that we have a problem, but judicial officers. One of the issues in terms of the appointed judges, we do not have a problem, but we are finding more and more that there are death threats that are done towards our judicial officers. So what we have done is that we have agreed within the justice cluster that a special mechanisms will be to fast track the assessment of the risk and support to judicial officers. So this is work in progress, but we said we'll monitor how our teams in the executive as that supports, for example, in the justice system, how they supported the judiciary in that regard, especially where there are death threats and all that, so that there isn't a delay and we do not end up with judicial officers being facing their death because of their work. Then in terms of security in the courts, we've done an analysis as well. One of the issues that we found, Chair, which members would have, as you do your oversight, is these things that you find. One is the infrastructure that is old. So you'll have x-rays, machines that are there that are obsolete because they are more than 15 years. You'd find that in terms of human capital, so instead of having 50 human bodies in terms of security, you'll have less. And this I'm flagging because these are shared services between ourselves and are driven by the department. And I'm flagging them because part of what I will speak to later, you'll understand in what we have said as a way forward. So even in this area, Chair, the budget cuts have affected us. So we flag this to say we need to sit on the table for the National Treasury to understand that the financing in these areas within the Department of Justice budget is not for us. It's for support of the judiciary, which is the another arm. So part of the issue is to start eliminating those, removing them and identifying them so that they are ring-fenced and they're not affected going forward. So this, again, I'm flagging because when you later, Chair, in the year, maybe through MTDP and the next budget, when you see the changes in the outer years, they would be informed by these conversations that we are having with National Treasury, but also the judiciary to identify where the gaps are and what needs to be done. Following that, Chair, I must say that there was a meeting between the executive, led by the President, and the judiciary, led by the Chief Justice. Out of that meeting, the agreement was that there was an initial process that was started by then Minister Jeff Hadebe. That was meant to ensure, it was 3 phases, that was meant to ensure the full independence of the judiciary. We were able to implement phase 1, phase 2 and 3 were pending. We have agreed to conclude those 2 phases. What does that mean, Chair? This means that the judiciary will be fully independent. We are looking at the legislation that, so it will be, we will have to develop a new legislation that will be almost taking similar format as the parliament legislation, where you have the, like in the parliament, you have the speaker as the executive authority. So within the judiciary, it will be fully led by the CJ as the executive authority and SG as the accounting officer, not the minister being the executive authority of OCJ. And secondly, in terms of single judiciary, so that even the magistrates are under the OCJ. And that work in terms of support for magistrates and also one judiciary, it's part of the work. So we've agreed that in the next 2 months from the meeting time, we will convene a meeting where the team will present a transitional method, proposals for us to look at in terms of the processes. And then out of those, then a long-term process, including the legislative amendment, and with timeframes will be presented to the judiciary and reported to cabinet. So we'll definitely do a cabinet memo to report, and we'll obviously report to parliament as well in relation to this work. I thought it's important, Chair, and it's one of the good milestones, because this is one of the areas that has been pending over time for us to be able to deal with, and also give the judiciary its full independence, and not having an executive authority being a minister who is also in the executive arm. So for the arms of state to be independent from each other, but supportive of each other and interactive of each other, this is one of the elements that we've got to fulfill. So I thought, as my opening, Chair, I bring this update to the committee, and we're looking forward to the engagements, and I'll hand over to the acting SG to take us through the presentation. Thank you very much, Chair.
Thank you very much, Minister. Acting SG.
Thank you, Chair. Thank you, Minister, for those words. Chair, I'm going to start the presentation, mindful also of time, just with some introductory remarks. As
Where
I
are you?
think
We can't see you.
my camera not on. It's on.
Yeah, the last we saw you is when you were busy with some technical team there.
Apologies. There is always sorted. Thank you. Yes. Are you sorted? Thank you. Thank you, Chair. Chair, I think before we start with our APP and strategic plan,
We
I
still
need
can't see
back-
you, Acting SG. Yeah, we see you now. We see you now.
May I proceed? Thank you. Chair, thank you. We will proceed with our presentation on the APP and strat plan. Before that, I need to make some introductory remarks. And to start off, the OCJ is humbled and appreciative of the support and guidance from this committee, and especially from the Minister, who has assisted us with engagements with the Minister of Finance, and it has resulted in a budget injection to allow us to capacitate the OCJ fully over the MTF period in order to enhance our support to the judiciary. I need also to mention that the leadership that we've received from the Chief Justice Maya and the heads of court assisted the OCJ in steadily enhancing the support to the judiciary by firstly then capacitating the courts through the filling and creation of immediate needs, whilst modernizing court processes and enhancing access to justice through the judiciary-led court online system. The OCJ Chair and members has continued to execute our constitutional mandate of supporting the judiciary. During this period, the department achieved 83% of its annual targets compared to the 86% of the previous year. There was a slight decline, which could be ascribed to budget cuts, as alluded to by the Minister, and the impact of Circular 49, hampered mostly the capacitation of the OCJ and achievement of our targets. We've achieved a clean audit outcome in 23-24, and we await the current outcome. And I've already alluded to the court online as part of our promotion to access to courts. The rollout of the court online system to all service centers remain our strategic priority. We can report to the committee that we've got 15 service centers where the system has been rolled out, and the OCJ remains committed to embracing technology as a means for courts to optimize operations, accelerate case resolutions, and enhance the overall experience for litigants and legal professionals. It's also necessary to note, Chairperson and committee members, that on the 27th of May this year, the High Court of South Africa and Gauteng Division, Pretoria, granted an order in favor of the OCJ in which the OCJ seek to self-review its procurement of case line from Thomson Reuters. The civil side of this matter has therefore been concluded successfully. An interim contract is in place to ensure business continuity in the court online system, and the procurement process has been started and almost concluded by CETA for a new fresh contract in that regard. Chairperson, the OCJ has further pursued the installation of backup generators and water tanks to address emerging risks previously highlighted. The OCJ was allocated a total budget of 2.6 billion, of which 1.2 was allocated to the vote and 1.3 to direct charge. Now, as alluded to, we have overspent as we could not afford even the warm bodies of the OCJ. Hence, the additional budget injection that will allow us not only to fund warm bodies, but to increase our establishment with the immediate needs received from the judiciary. In that regard, we are really appreciative for National Treasury, which has allocated us the additional budget. The OCJ has embarked on a recruitment drive.
Acting SG.
Yes, Chairperson.
Can you please zoom the slides to be a little bit bigger?
Let me ask my assistant, Des, can you please?
It's too much now, just a little bit.
Is that better, Chairperson? A bit too much?
No, yeah, this one is supposed to be better, but it can't appear. Just a little bit again.
Slightly, please. CIO, could you please assist?
Okay. Okay, it's fine. We can leave it here.
We're not used to Zoom. We are used to Teams. So it's a learning curve for us all. Thank you for your patience in any event.
It's fine.
Thank you. So, Chairperson, we have embarked on a recruitment drive to capacitate the institution, coupled with an organizational review to ensure that the structure for the first time since the establishment of the OCJ reflects the needs for the judiciary, whilst enhancing our support to the judicial arm of state. Now, Chairperson, I also need to note that the OCJ in 2025 has entered a transitional period with the departure of our former SG. And this executive team has, however, faced adversity and the inherent factors of a transitional period head on, and slowly but surely we are making inroads as a team that is working as a collective to improve the support to the judiciary and enhance our service delivery to the members of public. On that high note, Chairperson, may I kindly ask our Acting Chief Director to present the APP, Strat Plan and APP, as he has put in many hours to get all stakeholders' input in this final plan. Thank you. Mr. Masilo.
Acting SG, Mr. Masilo must know it doesn't have many hours to present.
It's noted. Thank you, Minister. You will
Yeah, if,
provide a-
I don't know,
Thank you.
Chair, how long do you give for all of us? Because I'm worried
Yes.
you do have another entity that is coming.
Yes, Mr. Marcelo, are you able to take 30 minutes?
I'll try my best, Chairperson.
15 minutes.
Please try your best.
Oh,
Just be economic with time.
no, thank you very much, Honorable Chairperson. Good morning to you, and good morning to the Minister and Deputy Minister, as well as honorable members of the Portfolio Committee.
Hold on, Mr. Marcelo. Someone is calling upon me.
Yes, Honorable Nomvalo.
Yes, Mr. Nomvalo.
Apologies for interjecting. I just want to check, Chair. Are you able to see on your side if someone is raising their hand?
I see you now. Sometimes I see, sometimes they just don't appear. So if you raise your hand and I'm unable to see it, you can just call for my attention as you have just done. It's fine.
All right. No, thank you. I just wanted to check that, Chair. Thank you.
Sharp. Mr. Marcelo?
Thank you very much, Chairperson. Safe to say that through your permission, if I start from slide number 6, and I'm not going to speak word by word on slide number 6, but it depicts the purpose of us being here today, which is to present the Office of the Chief Justice Strategic Plan for 2025-2030, as well as 2025-26 Annual Performance Plan. Then moving to slide number 7, is with regard to the introduction. It depicts the proclamation as well as the establishment of the Office of the Chief Justice, which was proclaimed by the President of the Republic of South Africa as the department in 2010. Then also the purpose thereof are outlined on slide number 7. Then moving again on slide number 8, we are dealing with various policy framework that we considered while developing both the strategic plan as well as the annual performance plan. And safe to say that we've considered the National Development Plan Vision 2030 as our point of departure. Then we considered the 2024-2029 MTDP. We looked at the DPME's framework for strategic plans and annual performance plan. Then we looked at the priorities of the judiciary as well as priorities of the executive authority. We also considered the DPME's guidelines for the development of 2025-2020 SP and 2025-26 APP. The last policy framework that we also looked into is the 2025 State of the Nation Address. And moving along through to slide number 9, it highlights the stakeholders that were consulted while developing this planning document. And through you, Chair, allow me not to highlight those that were consulted. We looked at both internal stakeholders as well as external stakeholders. On part A, on slide A, is our mandate. Slide number 11 speaks to constitutional mandates, and it remains the same. I'm not going to speak to that as determined by a Minister of Public.
Yes, Mr. Marcelo. Yes, Mr. Marcelo, you can skip the mandate.
Oh, okay. And again, through you, Chair, can I also skip the legislative and policy mandate outlined from slide number 12 to slide number 15? They are listed in our strategic plan as well as the APP. Okay.
Yes, yes.
Moving to slide number 16, we have highlighted those institutional policies and strategies that the OCJ will contribute towards. We have identified chapter 13 and chapter 14 of the NDP Vision 20, that of building a capable and developmental state, as well as promoting accountability and fighting corruption. Then we have also identified the 3 strategic priorities as outlined in the 2024-2029 MTDP. But then as we move along, we will be highlighting how are we going to contribute towards attaining these government priorities. Then in terms of slide number 18, it highlights the vision, mission, and values of our department. The vision remains the same as well as the mission, including even the values. Then in terms of slide number 19, we looked at the environment, external environment as well as the internal environment that might affect the work of the OCJ, and I'm not going to speak to that one. Then going to measuring our performance, as the OCJ, we have identified our impact statement, which is efficient, effective, and accessible justice for all. It's outlined on slide number 21. Then on slide number 22, we have also identified 3 outcomes. Outcome number 1 is effective and efficient administrative support, and we have linked it to chapter 13 of the NDP, which is building a capable state, as well as MDTP strategic priority number 3, which is building a capable, ethical, and developmental state. Then in terms of our outcome number 2, which is improved court efficiency, we are aligning ourselves with chapter 14 of the NDP, which is promoting accountability and fighting corruption. And then we also aligned ourselves with the strategic priority number 3 of the MTDP. Then the last outcome, which is enhanced judicial performance, we have also aligned ourselves with chapter 14 as well as of the NDP, as well as strategic priority number 3 of the medium-term development plan. Then in slide number 23, we are highlighting how are we going to contribute to strategic priority number 1, as well as priority 2 and 3, in ensuring, in contributing towards driving inclusive growth and job creation. We are committing ourselves that we will be implementing equity programs, most especially by prioritizing youth, women, and people with disabilities in recruitment processes, as well as targeting women, youth, and people with disabilities in procurement processes. And all these are unpacked in our annual performance plan in a form of output indicators, as well as annual targets and quarterly targets. Then how are we going to contribute to reducing poverty and tackle the high cost of living? We are saying by promoting social cohesion and nation building, by ensuring superior costs are accessible to all, by bringing services closer to the people, especially those in rural areas, as alluded to by the minister. Then secondly, we will be partnering with relevant stakeholders within the justice cluster to bring services closer to the people and implement various public awareness campaigns and community outreach programs. Then in contributing towards building a capable, ethical, and developmental state, which is strategic priority number 3 of the MTDP, we are committing ourselves in modernizing court and court digitization by rolling out court online in all superior courts. Secondly, we will be developing and implementing OCJ anti-corruption strategy and plan in line with the national anti-corruption strategy, and we will be enhancing whistleblower and fraud reporting mechanism, amongst others. Then moving along to slide 24, safe to say that in our strategic plan, we have 3 outcomes. as well as 4 outcome indicators and 4 5-year targets. In ensuring effective and efficient administrative support and contribute towards building a capable state as Chapter 13 of the NDP, as well as contributing to MTDP priority number 3, that of building a capable, ethical, and developmental state. Our first outcome indicator is reduced vacancy rate. Currently, we are sitting at 12.79%, and we are targeting that come the next 5 years, we should be at 10% or lower. So that's how we want to reduce the vacancy rate. The second outcome indicator at SP level is with regard to modernize superior courts. Currently, Court Online has been rolled out at superior courts. Then we are intending that come the end of the 5-year term, the Court Online should be rolled out in all superior courts in the country. Then zooming into outcome number 2 of improved court efficiency, we will be contributing to Chapter 14 of the NDP, that of promoting accountability and fighting corruption, as well as MTDP priority number 3 of building a capable, ethical, and developmental state. And our outcome indicator in this regard is a percentage on finalization of quasi-judicial matters within prescribed timelines. And this is a new indicator, so we don't have the baseline. Then our 5-year target is 94%. Then zooming into the next slide, which is slide number 25, in line with the outcome number 3, which is enhanced judicial performance and contribute towards promoting accountability and fighting corruption, as well as building a capable, ethical, and developmental state. We've got an output indicator, which is increased judicial education courses. Currently, we've got a baseline of 626 judicial education courses that have been conducted. And for the next coming 5 years, we are targeting to conduct 675 judicial education courses for judicial officers as well as aspiring judges. And then, Chairperson, in a nutshell, these are the outcome indicators in our strategic plan. Now I'll focus on our commitment outlined in our 2025-2026 annual performance plan. And as we all know that the Office of the Chief Justice carries out its mandate through 3 programs. Program one is administration, then program 2 is superior court services, and program 3 is judicial education courses. And safe to say that in 2025-2026 financial year, we have 20 output indicators as well as 20 targets. Looking at administration program, on slide number 28, we have highlighted the purpose of the program, which through you, Chair, allow me not to speak to that. And we also outlined the sub-programs under program 1, and we also outlined the brief description of each and every sub-program. In terms of our first output indicator, it's on the audit outcome for the OCJ. In 2025-26, we are targeting to obtain unqualified audit opinion with no material findings, which normally is in audit for the 2024-25 financial year. Then even the same will apply throughout the MTEP, even in 2026-27 financial year, including 2027-28 financial year. Then the second output indicator is percentage of procurement of goods and services above 500,000 awarded to suppliers who meet the specific goals, excluding state-owned entities, and we are targeting 100% over the MTEP period. Then zooming into the third output indicator under program 1, it's on percentage of valid invoices paid within 30 days, and we are targeting 100% even over the MTEP period. And the fourth indicator under program 1 will be on percentage of designated employees. This will refer to SMS members and other categories who submitted financial disclosures within time frame. then we are targeting 100% over the MTEP period. Then on the fifth output indicator, we've got the vacancy rate maintained at 10% or below. We are targeting 10% or lower throughout the MTEP periods. Then the sixth output indicator is on percentage of staff in the department comprised of youth. We are targeting 30% from 2025, 2026 to 2027-28 financial year. Then on women represented at SMS level, we've got an output indicator on percentage of women representation in SMS. We are targeting 50% over the MTEP period. Then the next output indicator, which is on slide 31, is on percentage of people with disability representation in the department. We are also targeting 2% over the MTEP period. Then the ninth output indicator is on number of superior courts with court online system rollout. This is the output indicator where we amended our annual target as per the advice from both the executive authority and the judiciary. So we aligned ourselves with the priorities of the judiciary. So in 2025-26, we are targeting 30 superior courts with court online system rollout. Like I mentioned before, we already have 8 in 2024-25. So in 2025-26, we are targeting 13. Then in 2026-27, we will be targeting 2. Then when we add all the numbers, we will be having all superior courts with court online rolled out. With court online rolled out. Then the last output indicator on program 1 is on percentage of reported fraud cases investigated within 90 days, and we are targeting 75% over the MTEP period. So this is more on the annual target. Through you, Chair, can you allow me to skip the quarterly targets? Because this one we are just indicating how are we going to contribute on a quarterly basis towards attainment of our annual targets.
You are granted.
Okay, thank you very much, Chair. Then I'll quickly zoom into slide 35, which depicts Program 2, the Superior Court Services, which is the core business of the Office of the Chief Justice. The purpose of the program has been outlined, as well as its sub-programs, and a brief description of the sub-programs has been also outlined. Then I'll quickly jump into the output indicators for this for this program, and safe to say that this program has got 5 output indicators as well as targets. Then, on the first output indicator, which is percentage of default judgments finalized by registrars within 12 court days from the last date of receipt of application, we are targeting 90% in 2025-26. Then there will be a slight increase by 1% in 2026-27. A further 1% increase in 2027-28. So it will be 90%. Then we'll be targeting 91% and targeting 92%. Then moving along to the second output indicator, it's on percentage of taxation of opposed legal bills of cost finalized within 60 court days from date of set down. We are targeting 90% over the MTEP, 98% over the MTEP period. Then on the third output indicator is on percentage of taxation of unopposed legal bills of cost finalized within 40 court days from date of set down. Then we are targeting 99% over the MTEP period. Moving to the next slide, which is slide 37, the fourth output indicator is on percentage of warrants of liberation. J1 delivered within 1 day of the release issued. We are targeting 100% over the MTEP period. And lastly, on the number of judicial case flow management performance report produced, we are targeting 4 over the MTF period. Honorable Chair, before stepping out on program number 2, we've got a section in our APP, which is the technical indicator description, where we unpack and describe what do we mean by some of these output indicators. Like when we are talking about the court days, what are we referring to? Then moving to the third program, which is judicial education and support, on slide number 39. Slide 40 outlines, it describes, it highlights the purpose of judicial education and support. Then we also have the brief description of the sub-programs under judicial education and support. And safe to say that even for program 3, we've got 5 output indicators as well as 5 annual targets. The first output indicator is on number of judicial education courses conducted. We are targeting to conduct 125 judicial education courses in 2025-26. Then it will be followed by 130 judicial education courses in 2026-27. Then in 2027-28, we are targeting to conduct 135 judicial education courses. Then the second output indicator is on the number of judicial education newsletters produced. This we are targeting 3 over the MTF period, which means that in 2025-26, we will be producing 3 of judicial education newsletters. The same will apply in 2026-27 as well as 2027-28. Then the third indicator will be on the number of reports on the management and coordination of litigation reports. We are targeting 5 over the MTF period. Then the fourth output indicator under program 3 is on number of reports on judicial appointments and judicial complaint reports. We are targeting we are targeting 3 over the MTF periods. Then the last output indicator is on the number of reports on the status of disclosures for judges' registrable interest produced. Then we are targeting 2 over the MTF periods. The next slide, Chair, it's mainly on our quarterly targets, which are in line with our annual targets. Then in terms of slide number 44, it's on a technical indicator description. We through your permission, Honorable Chair, allow me not to take honorable members through the definition of some of these indicator titles because they are there in the threat plan as well as in the APP. But then we have highlighted those new output indicators that are outlined in our strategic plan, and that is from slide 45 until slide 46.
Granted.
Thank you very much, Chair. Then looking at the key risks, which are outlined on slide 48 and 49, we have identified 6 key risks in our APP as well as the strategic plan. The first one being ineffective governance structures, and we have also outlined the risk mitigation, which through your permission, allow me not to read them out. But then the second one will be failure to retain competent staff. Then the third one will be non-compliance with applicable legislation, including the courts. Then the fourth risk is misalignment of
Hold on, Mr. Mbegi. Mr. Mbegi. Mr. Mbegi.
Yeah, unmute.
Please proceed, Mr. Marcel.
On the organizational structure, then we also highlighted the risk mitigation. On slide 49, we have highlighted another key risk, which is compromised IT security. with specific reference to cyber attacks, hacking of departmental system, and the last key risk is on compromising physical security for both costs. That will be infrastructure and personnel and judiciary. Honorable Chair, this marks the end of my presentation on our commitments for the next 5 years, as well as 2025-2026. Yeah, the last part will be on financial information. Thank you very much, Honorable Chair.
Thank you very much, Mr. Masilo. Who's doing budget?
Our CFO, with your permission, Chair, will then proceed with the financials. Thank you.
Thank you, CFO. Please proceed.
Morning, Chair. Morning, Honorable Minister, Honorable DM, and the Honorable Portfolio Committee members and the colleagues. I'm going to present the financials. On the financial, Chair, we, as the Minister and also the acting SG has already indicated that we, as we've been presenting also to the Portfolio Committee in the previous financial year on the shortage of budget, we then had the spend on the 24-25. He just indicated that we had a spend of, we spent 2.8 billion, of which our budget was 2.7 billion. So we just wanted to indicate, we'll elaborate more when we come to the annual report, when we present the annual report. On the MTF period, Chair, we then received in the new financial year 2.752 billion, of which 1.5 is for the voted funds, and then the 1.2 is for direct charge. And then on the compensation of employees, that's where most of our budget is. We then have 2.153 billion, which is for direct charge and the voted funds. And then for goods and services, we then received 407. And then for transfer and subsidies, purchase of capital assets, we received transfer and subsidies, mostly it's for the judges' gratuities, the 102. And then purchase of capital assets is 89 million. And then on the transport, where we then procure for the judges' vehicles, it's 76 million. And then other machinery equipment is 13. The total budget is 2.7. And then on the 25-26 overall budget, it increased from voted funds, it's 1.6. And then on the judges, it's 2.9. Again, also on our budget for COE, it also increased. And also on goods and services, we received an increase on that budget. The transfer and subsidies, the same, we receive increase, and then on capital assets, then it decreased. On the transport also, it decreased on the vehicles, because I will explain in the next slide, Chair, on the reason for why it now decreases. And then on the overall budget, we received 2.9. Then the 27-28, again, we receive increase on voted funds, 1.7. And then on judges is 1.3. The total budget is 3 billion. And then on the COE, again, it's increasing. The same with goods and services, increased to 466 million. And then on transfer and subsidies, 119. Purchase of capital, it's decreasing again, mostly decreasing under the transport and equipment, which now total our budget to 3 billion on the 27-28. So on the 3-year period on MTF, our budget is increasing. And then we just saying on the next slide, the slide 52, is just to say that the budget for 25-26 is 2.7 billion, which includes the direct charge from National Revenue Fund for judges' remuneration. Allocated budget, voted as I've indicated, is 1.5. And then 1 million is for compensation of employees for officials. 407 is for goods and services. 1 million is for transfer subsidies. 89 for capital. Budget for direct charge, 1.237 billion is for direct charge. Compensation is 1.13, and then 101 is for transfer subsidies. The next slide, Chair, is just to break down the budget for the MTF for 25-26, which is 1.5, 1.27, and then 55% is for voted funds. Direct charge is 45%. Most of our budget, which is for compensation, you can see most of the budget for COE is for direct charge, which is 53%. And then for officials voted is 47%. On the next slide, Chair, is just to show, as we also want to thank the Portfolio Committee, the Minister, for assisting us to engage Treasury, because we've been presenting in the previous financial year the expenditure that reflected that we are overspending. So through those engagement, OCJ now received 882 through the MTF period, of which from 25-26, we are from 2.7 and will end up at 3 billion. What we received for under the COE, we received 90 million for 25-26, 126, 168, and then for the adjustments also we received 18 million, 19 and 20. Goods and services we received 105, 11, 111 and 118. And then also machinery we received 45, 30, 25. I must indicate, Chair, the machinery equipment, the budget that we received here, when we were also engaging with Portfolio Committee in the previous financial year, we indicated that the issue of the vehicles for judges, it's where we are spending a lot of money for the procurement, because we are leasing those vehicles. So those vehicles on slide 54, the 45, the 30, Treasury then allocated funds to then procure outright purchases where the vehicles will be owned by the OCJ. So we have started that process, Chair, to procure for judges who are due to renew their vehicles. Now we have started to procure the vehicles out of outright purchase, but it will go on phases in the coming MTF period. The issue also of where the minister have indicated that even though we might have received increase, there are new requests from the judiciary where we need to now create more new posts. There are new posts that we need to create in the establishment. So the other issue just to mention is the issue that even this new budget, we're gonna now able to fund the SAJ bill. And also they've given us more money to fund also the bandwidth that we presented previously on the quarter line. Other matters that we are still engaging National Treasury is the issues of the land court, the new bill of the land court, but we have started to also capacitate that the shortfalls will be on those issues where now, because we've been engaging, as Minister have indicated, the issues of security, those shared services, we all indicated that we don't have a budget. So if those shared services process comes to OCJ, we'll need more budget for resources and other matters on the shared services. I think that's the end of my presentation, Chair. Thank you.
Thank you, Chair and members. There is a presentation from the Office of the Chief Justice. We are ready to take questions. Thank you, Chair.
Thank you very much, Acting SG. DM, any issues to point out?
Yeah. Chairperson, thank you very, very much. Greetings to yourself, members of the committee, the Minister, the acting SG, the DG, and all officials. No, I think the Minister has outlined very, very comprehensively the steps being taken by the department. I think the strategic plan and the APP are clear and detailed. I think I just want to raise 3 points, is that all of this, I think we need to see again in the context of the mandate of the Department of Justice and Constitutional Development. Firstly, in honoring our obligations in terms of Section 165(4) of the Constitution, which enjoins all organs of state through legislative and other measures to assist and protect the courts to ensure the independence, impartiality, dignity, accessibility, and effectiveness of our courts. Secondly, I think the Minister alluded to the discussions that were held recently at the meeting between the President and the Chief Justice. the Minister and other members of the executive around the strengthening of judicial independence, and in particular, a judiciary-led court administration model, and secondly, a single judiciary. And that's consistent with Schedule 6, Clause 16 of the Constitution, which provides that as soon as is practical after the new Constitution took effect, all courts, including their structure, composition, functioning, and jurisdiction, and all relevant legislation must be rationalized with a view to establishing a judicial system suited to the requirements of the new Constitution. I'd like to repeat that last clause. Establishing a judicial system suited to the requirements of the new Constitution. And in that regard, the Constitution provides that the cabinet member responsible for the administration of justice, acting after consultation with the Judicial Service Commission, must manage the rationalization envisaged in paragraph 8. So I think whilst the presentation today was very detailed and delved into a number of more technical and administrative matters which are vitally important to the functioning of our courts, I think we must always see it in the broader context of giving effect to those provisions of the Constitution. Lastly, Chairperson, it might be a bit of a small matter, but maybe it appeals to those of us who have a slightly academic bent of mind. I don't think it was reflected in the APP under the South African Judicial Education Institute that they have taken the initiative to launch an accredited academic journal for the Institute, which has the first issue of which has come out. And we hope that there will be many, many more of that, and that it really provides a forum for the judiciary also to engage in that vibrant debate that should characterize our constitutional democracy. Thank you very much.
Thank you very much, dear. Members, can we now interact with the presentation? Honorable Nomvalo, Honorable Swart, Honorable Mhlala, Honorable Klopper, in that order, members.
Chairperson, may I indulge that I possibly go first as I'm logging off in 2 or 3 minutes? Only if it's your indulgence.
You are what?
I'm logging off in 2 or 3 minutes, as I said. Is it a possibility I could go first? If not, I understand.
Okay, Honorable Nomvalo, okay, let's please allow Mr. Klopper to come first, then we'll start with you immediately after him. Thank you very much.
Thank you, Chairperson. I really do appreciate it. I will be short. Chairperson, the OCJ remains committed to embracing technology as a means of courts to optimize operations and so forth. But what does concern me is that most courts that you visited are plagued by technological failures. We hear of unreliable internet. We also see that most of the metal detectors are not working. That's something that you're concerned about, or something that you're really working on?
Chairperson, we badly hearing what Honorable Klopper is saying.
Yes, Honorable Klopper.
We can't respond when we can't hear.
Can
you hear me?
We are losing you, Mr. Klopper, and unable to interact with what you're saying.
I was asking about the technological failures such as metal detectors at the courts. Can you hear me?
Okay, you are better now. You can proceed.
I think Mr. Klopper is wanting to illustrate his point very vividly and practically.
The technological issues.
Yes,
Mr. Klopper,
technology escapes us.
Yes.
Chairperson, I'd just like to know about the improved strategic priority number 3 in the hot badge reporting, about the witness protections. I just want to know about a little bit more about that. And then there was speaking or mentioned in the report about conducting lifestyle audits. Has this been completed? Has there been any outcomes of these lifestyle audits? And I will end there for us.
Thank you. Minister, did you get that? The last part speaks about the lifestyle audits, which is part of the report of the OCJ.
Yeah, I
Okay.
picked up 2 issues. Thanks, Chair. I think we'll
Okay.
try our best. I think even the team where they picked up, they would be able to.
Okay. Honorable Nomvalo.
Yeah, thank you very much, Chairperson, and greetings to everyone who's part of this meeting. We just want to start by saying, Chair, that we agree with what has been said, I think, by the Minister about the restructuring of the judiciary, because it is dictated to by the Constitution, in particular Section 165, which says that the judicial authority rests in the courts. It's just that it doesn't say it rests in the Chief Justice, but it says in the courts. That's what the clause is saying. Now we agree, and we are very worried, especially from my organizational perspective, with the current arrangement. We view it as an unwarranted encroachment that you find the executive in the affairs of the judiciary. The judiciary must be independent, and we must cement by all means necessary its independence. And the Chief Justice, as it has been said, must be must have the judicial authority of the judiciary. So we agree with that proposition, and it will present an ideal judiciary which is independent, which is free from interference, in particular by the executive. The judiciary must independently and directly be accountable to Parliament, because Parliament has a constitutional obligation to do oversight, and it must do oversight both in the executive and in the judiciary. So we believe that that kind of arrangement will minimize problems of infiltration, interference, undue interference, and so on and so forth. And they must have their own budget, to which they will have a determination in terms of how it is spent, and they must not rely from the executive for them to exercise either their administrative or their judicial responsibilities. So we agree, Chairperson, and it's what we have been openly and vividly advocating since we got into Parliament. So we think that is in line with our objective. Now, secondly, Chairperson, I was expecting that in this report we're also going to be updated about the courts which are currently under construction. Remember that when we were doing oversight in Durban, the High Court is under construction. I can't remember the exact percentage in terms of progress that has been made in that construction. But what we learned is that the High Court temporarily they moved to the Magistrate Court's premises, and that is a temporal arrangement. But they will go back to the High Court upon completion. So what we were hoping to get, because I don't know how many courts in the whole country are under construction, we're hoping to maybe be taken through in terms of getting an update of when these courts will be completed, and if this budget maybe will be enough for that completion. But Chairperson, I think if we are all honest, we would arrive to a conclusion that sometimes it's unfair to be hard on the OCJ because they operate under a very limited budget. And the current arrangement does not allow flexibility on their side because they have to rely on CETA, they have to rely on public works, they have to rely on the executive. And it imposes many constraints on their part. That is why, so we just wear soft gloves when we are dealing with them because we understand the circumstances under which they operate. But to us, Chairperson, an ideal court arrangement which will enhance and cement access to justice is an arrangement wherein you will have the local divisions in every district. I always make an example of KZN, for instance, because KZN is a very vast province with a very few courts. You have Pietermaritzburg High Court, which is a provincial division. You have a place called Ngwavuma, which is close to Mozambique. Now, traveling from Ngwavuma to Pietermaritzburg is above, I think, 400 kilometers. Now, for people of Ngwavuma to have access to high court matters, I mean, for them to have access to justice for high court matters, they have to travel such a distance. Now, it's better when you say you decentralize the high courts into districts and not rely on the apartheid special development kind of arrangement, because it impedes universal access to justice. So we just want to sell that idea to the OCJ that will continue because we're very interested in an efficient justice system. So that we must consider in our plans that an ideal judicial system will include enhancing and decentralizing the high courts to districts for easy access by members of the public to such courts. And you would remember, I think the members of this committee would remember, Chair, that when we're doing oversight, we asked a question from the SG about the support system. I mean, the support systems is including the support staff that the judges have, the number of researchers, the number of PA, and if my memory serves me well, the response that we got is that each judge, 3 judges share 1 PA and 1 researcher. And we lamented that considering the amount of work that judges have. But equally considering the fact that now we have a very congested court roll, which makes members to get dates for trials which are very far. If you go to court today, if your matter is settled down today, is set down today for trial, you might get a date for 2026, towards the end of 2026 or early 2027. Now, that is an impediment now to a proper running of justice, a system, and it's not ideal. An efficient justice system is a system in which matters are quickly resolved, because the more matters get unnecessarily prolonged, is the more a threat to a justice system fines expression, because people, there are many events that come in between a period of taking a matter to court and a period of finalizing it. If it's not finalized expeditious, I mean within a very limited period of time, the evidence sometimes gets disrupted by nature. People die, witnesses die, the evidence gets destroyed, and so on and so forth. So, an ideal justice system is a system wherein matters are quickly resolved. So, we believe that decentralizing the courts, hiring more judges will help the situation. I hear the modernized system that has been presented here. We just believe that it's one of the facets that will help the situation, but not in its totality. We just need to consider this one of decentralizing courts and giving more support system to judges so that they are not going to work under a strenuous environment where they have to share the PAs, and some of these PAs sometimes, because the judges, they deal with very complex matters. You find that writing a judgment, for instance, it will require a person who will write a judgment which is about 80 pages. And there are matters which are complex and which would coincide in some instances. Now, it's difficult for those PAs to be efficient under that environment. So maybe the presenter has missed mentioning that part, but we were really expecting that will be taken into confidence in that regard, Chairperson. Chair, I think we agree that CETA is a threat to a service delivery, based on the experience that we have and based on the experience that we got. You'd remember that some of the scanners were not working in court, and the whole explanation was around, and some were not working for a very long time, and the justification was around the inability of CETA to respond urgently to some of those problems. Now, I don't know if maybe there is another way that we can minister, that we can, or maybe if you have engaged in trying to help the situation. In Durban, I remember in Durban courts that the scanner was not working when we got there, including in Tuzuma. I know that those are magistrate courts. I'm just making an example with them. Here we're talking about the high courts. But I'm saying because CETA is also responsible for some of the infrastructure in the high courts, and they also have a problem because currently the High Court is operating in the premises of the Magistrate Court in Durban. So they also get affected by these CETA problems. So I don't know what plan the minister has since she arrived in office has adopted to ensure that they address that problem. Because some of this infrastructure is new, like in Tuzuma Magistrate Court, but it's not properly maintained. Yeah, and then the last point, Chairperson, is the point around the training of judges. I thought maybe we're going to get a fully fledged presentation on that. How do we intend to train judges? Because some of the judges really, when they write, I mean, you can hear that when they write judgments,
Mr. Nomvalo. Mr. Nomvalo. Members, can you hear me?
We can hear you,
We
Chair.
can hear you, Chair.
Okay.
Chair,
Yes.
I think Mr. Nombalo got disconnected.
Oh, I think he's affected by network. Okay, that's fine. Mr. Swart.
No, thank you, Chair, and good morning to the Minister, the Deputy Minister, and the Acting SG for the Office of the Chief Justice. And I just want to thank the Minister, DM, and the Office of the Chief Justice for their report. I think what I need to emphasize, like I did yesterday, is the fact of the budgetary constraints. And whilst there was an additional funding given to the Office of the Chief Justice, it's still nowhere near where the requirements are. And if one considers the most recent budget speech of the Minister of Finance on the 21st of May, he states the spending pressures that may require funding later this year include strengthening the capabilities of the Office of the Chief Justice. So, as the Acting SG indicated, it is obviously that additional funds were given, but not sufficient as is required when one considers, and we've done oversight in the previous parliaments, we've done oversight this time of the shocking state of buildings at a high court level, and of course we know at a magisterial level. And so this places a lot of pressure. We are fully aware of the delays that are caused when it comes to trial dates with insufficient judges that need to be appointed, and obviously the supporting staff that needs to be also appointed. I think the Honourable Nomvalo pointed out about the trial dates. I think this is a very, very important point, particularly when it comes to the pressures and the backlogs in certain of our courts. And one reads about the North Gauteng court where you have to wait 5 years for a trial date. This is unacceptable, and it obviously is an indication of the fact that there are too few judges, but also that alternative dispute resolution needs to be adopted, such as in RAF cases. Chairperson, I want to just touch on the issue of accountability, because I think this is very important. We fully appreciate that the Office of the Chief Justice is a government department, and we are concerned about the delays in the implementation of a fully independent judiciary model. This has come for many, many years, and we are mindful of what the outgoing Chief Justice Zondo, when he left, that was in 2024, was very disappointed that the talks with the executive branch to create that fully independent judiciary had stalled, as he put it. This has been going on for many, many years. And I know the DM pointed out about the Constitution being adopted in 1996 already. So this process, 15, 20 years, we appreciate, Minister, you giving us an indication that progress is being made in this regard. And you even spoke about certain timelines. But I think we would need, as a portfolio committee chair, to hold the executive far stricter to account, because you'll recall in the previous parliament, we expressed our disappointment in many of our debates that that model had yet not been finalized. So we would need to see some timeline. We understand this is a process that will require legislative reform. That does take time. Parliament will be involved as well, but we need to have some idea of a timeline. Now, that having been said, there is obviously an implication when it comes to accountability to Parliament when that model is accepted. We are fully aware of our parliamentary duties in terms of Section 55, which gives us oversight over the executive and organs of state. We're fully aware of Section 165, which Mr. Namvao pointed out, that the courts are independent and subject only to the Constitution and the law. But what is very important is Section 239, which states, and we know that Parliament can hold organs of state to account, but 239(b)(2) says that does not include a court or a judicial officer. So that whole area of the judiciary being accountable to Parliament is an area that is, one could say, a grey area, and this has resulted in the Chief Justice presenting her or his previously annual report to court, in the Constitutional Court. So, Chair, I think this is an area we need to look into as well. And I would urge that we again set up a meeting as the Portfolio Committee, as has been practiced in the previous parliaments, with the Chief Justice and heads of court, where we can discuss matters of mutual concern, which would include the issue of the independence of the judiciary and that independence model. Chairperson, that having been said in general, I think I would also like the Minister or the Office of the Chief Justice, I'm not sure if to what degree we would need a briefing when we would ideally meet with the new Chief Justice about the issues of fraud and corruption allegations at Umtata Court involving court officials. We appreciate the Minister alluded to that, but the Minister might say we should get a full report from the Chief Justice itself and the judiciary. I think that is an aspect that we do need to look into, and to what degree this is more widespread than only at Umtata. We're aware in the past of certain courts where court orders were fraudulently issued by court officials. This is obviously an untenable situation, and we need to be aware, is this more prevalent than only in the Umtata High Court? I think, Chairperson, it's obviously crucial for all of us to understand the need that justice must be seen to be given, justice must not be delayed, and so we would fully support additional funding to the Office of the Chief Justice, as we have continually said in the past, as we've said in committee reports. It is crucial that all these backlog cases are dealt with, both from a criminal perspective, the criminal cases, as well as the civil cases, given the fact that a lot of our economic growth is dependent on the speedy resolution of particularly civil matters, and we are fully aware of the very, very strong and very heavy backlogs which impact many of our claimants. When you look at the RAF matters, when you look at medical legal matters, when you look at police matters that were raised yesterday. So, Chairperson, we from our perspective also wish to commend the OCJ on the victory in the case lines matter, which was the ongoing matter. That also, and we appreciate that victory to deal with that tender, given the circumstances under which that tender was granted. But I do wish to just ask, what is the impact on the rollout on case lines, because that has been very effective in certain of our courts, and will one see that case lines is further extended? But what is the implication of that victory? One presumes that the project will continue with that rollout. Chairperson, at this stage, I'll leave it at this stage, but I just want to appreciate the work of the OCJ and her staff. Thank you so much.
Thank you, Mr. Swart. Nomvalo, we lost you when you were concluding.
Yes, I was concluding, Chair. Can I come in?
Yes, please.
Yes, Chair. I was concluding on the training, Chair, of judges. I just wanted to ask a question that will the training include a training on the ethics and morals on how the judges are expected to conduct themselves. I just wanted to ask that question. I'm asking it because, Chair, you would remember that on the previous financial year, we were very angry as the committee when we learned that there are judges which are being paid while they are still on suspension, and they have been paid for a very long time while their DC hearings have not been concluded. So I think the issue of being emphatic on the ethical and on the ethical behavior of judges to avoid, because an embarrassment on the profession as well, to avoid judges being taken to DC and getting salaries while they are on suspension. I just wanted to make that point and couple it with a question. Thank you very much.
Thank you, Honorable Mhlala.
No, thanks so much, Chairperson. Let me just try to.
There is an echo, Honorable Mhlala, where you are. When you speak, a voice just.
No, thanks so much, Chair. I think I'm proper now.
That's better.
I switched on 2 gadgets at least to make sure that the system doesn't kick me out because I'm experiencing network problem. I think I'm audible. Chairperson, let me take the opportunity and greet the members of the Portfolio Committee and also extend the greetings to the officials from the OCJ and the Minister as well. Minister today has presented a long overdue process aimed at strengthening the independence of the judiciary, which is a vital arm of the state responsible for upholding justice. We welcome this initiative and trust that the measures will be implemented efficiently and effectively so that we may establish a truly independent judiciary capable of fighting crime and restoring public confidence in the justice system. This aligns with Section 165 of the Constitution of the Republic of South Africa, which clearly states that the courts are independent and subject only to the Constitution and the law, which they must apply impartially and without fear, favor, or prejudice. Furthermore, it obliges all organs of the state to assist and protect the courts to ensure their independence, impartiality, dignity, accessibility, and effectiveness. So, Chair, it is therefore imperative that this process is not just symbolic, but result in real and lasting reforms that give full effect to the constitutional promise of a judiciary free from interference. The economic freedom fighters under our leadership, President and Commander-in-Chief Julius Malema has consistently raised this concern about the lack of genuine judicial independence in South Africa. The EFF have argued that while the Constitution guarantees judicial autonomy in practice, the judiciary often operates under the shadow of executive influence and political manipulation. So, Chairperson, in terms of the documents that were also presented today, I've got some input, a few inputs, and also some questions to the officials and the Minister. I think will be also assisted in that regard. Minister, the budget does not provide for a full and lasting solution to the serious problems with court buildings across South Africa. Many courts still have broken lifts, leaking roofs, and holding cells without water or electricity. These are not just small issues. They make it hard for people to get justice, especially those who are poor or vulnerable. The current budget only seems to cover small repairs, not big plans to fix all the building properly. If we keep patching things up, the same problems will keep coming back, and ordinary South African will continue to suffer delays and poor service. For example, we're told that at Durban High Court, judges sometimes cannot go to work because the lifts are out of order. The High Court is on the upper floor, maybe up until 15th floor. And when the lifts are not working, it is physically impossible for judges and staff members, especially those who are older or have health conditions, to reach their courtroom. We're told this has been a problem for years, with the lifts breaking down almost every week. This is not unique to Durban, Minister. Similar issues are found in many courts across the country. So why does this budget not include a clear, well-funded plan to fix all courts' infrastructure problem within the next maybe 3 years? What steps will you take to make sure every court in South Africa is safe, accessible, and dignified for all users? The other thing, Minister, is the budget does not provide for the modern security systems and anti-corruption technology that our courts urgently need. With recent cases of fraud and corruption in places like Mthatha and Pretoria High Courts, and which is happening also across the entire country, Minister, it is clear that our courts need better systems, like working cameras, secure access controls, and digital tools to track our files and evidence. Right now, there's no clear money set aside for these upgrades, which leaves our court open to more crime and corruption. Why does this budget not have a specific amount set aside for new security and anti-corruption technology in our courts? How will you make sure that our courts are properly protected from fraud and crime in the future? Minister, once more, the budget does not provide enough for training and supporting of court staff. Yes, we heard you have mentioned that there is something that you're going to do. While some money is set aside to fill vacant posts, there's still little for ongoing training, digital skills, or wellness programs. Staff are under pressure from backlogs and poor working conditions, and without proper support, we risk losing good people and failing to deliver quality justice to the people. Yes, we saw the APP, we saw everything. It spoke about training. But if you don't keep, and you also spoke about the filling of vacancies, training must be a very important thing, Minister, so that we ensure that we don't lose, and more especially as well, the wellness. So we did not see anything speaking about that. Another point, Minister, the budget does not provide for special programs to help vulnerable groups like rural communities, people with disabilities, or survivors of gender-based violence access justice. Upgrading buildings and going digital is a very important thing, but without targeted support, many people will still be left behind. In South Africa, where inequality is very high, we need to make sure everyone can use the courts, not just those who live in cities or have resources. Why is there no budget for outreach or support services for vulnerable groups? How will you make sure that everyone, no matter where they live or their situation, can access justice in South Africa? Yes, we heard about those digital, but it doesn't say that people in rural areas, some of them doesn't even have a smartphone for that matter to watch all those cases digitally. Another thing, Minister, the budget does not provide enough for independent monitoring, evaluation, or regular public reporting on progress. Without this, it is hard for Parliament and the public to know if targets are being met or if money is being well spent. In a democracy like South Africa, transparency and accountability are key. Why is there no budget for independent monitoring and public reporting? Will you commit to regular, clear updates or progress so that we can all see if the OCG is meeting its own target? The budget, APP, and the strategic plan do not address the ongoing problem of labor courts judgments that are reserved for years before being delivered. This leaves workers and employers in limbo, causing unnecessary hardship and undermining trust in the justice system. There's no clear plan or dedicated resources in these documents to monitor or reduce the backlog of reserved judgments, especially in labor courts, Minister. The Durban Court has judgments that have been reserved from 2021. Office of the Chief Justice issued the directive that the threshold for reserved judgment is only 3 months. What a contradiction. The former judge president for both Labor Court and Labor Appeal Court joined the queue despite the directive from the Office of the Chief Justice. So what are we going to do in that regard? Because I did not see it being addressed. Why do the budget, APP, and strategic plan not include specific measures or resources to address the backlog of long-reserved labor judgment? There's a labor judgment in KZN, I think, from one of the retired judges that took 12 years for that judgment to be brought to the people. So what action will you take to ensure that all South Africans receive timely decisions in their cases? Minister, while we understand that SITA does not fall directly under your portfolio, we must raise the issue because its performance affects the entire state, including the justice system. SITA is a very vital institution that must be supported to recover and function effectively. We acknowledge this regulation 17.8 as a measure to assist the procurement process, but it must never be used in a way that leads to the collapse or sidelining of this important state institution. Government must ensure SITA is strengthened, capacitated, and restored to play its full role in delivering efficient public services. I will pause there, Chairperson. Thanks so much.
Thank you, Honorable Mutau.
Thanks, Chair, for the opportunity.
Chairperson.
Greetings to everyone present in the meeting, Chair.
Hold on, Honorable Mutau. Honorable Mhlala, what's the issue?
Am I audible, members?
Yes, you are audible. Honorable Mhlala? Switch
Members?
off your video.
Chairperson?
Yes, we can hear you, but it looks like you can't hear you on the other side. Okay, Committee Secretary, can you communicate with Honorable Mhlala? Proceed, Honorable Mutau.
Thanks, Chair. Chair, the Office of the Chief Justice issued a statement regarding issues centered around corruption and impropriate at Umtata High Court. Perceptions of corruption and impropriate. About 3 years ago, matters of impropriate involving former employees at the OCJ were discovered and criminal cases were pursued. What measures are put in place to cap the potential fraud corruption in the OCJ, as this could attain the image of the judiciary? Secondly, Chair, what consequence management or consequence measures have been put in place in the matter of Mthatha? Chair, another thing, what are the reported timeframes for the investigation of fraud cases, given to the importance of protecting the integrity of the court environment? And why is the target only set at 75%? How many fraud cases did the OCJ investigated in 2024-2025 financial year? Chairperson, what is the OCJ doing in assisting the JSC in monitoring the personnel shift of judges across the judiciary, including monitoring of new appointments, retirements, and promotions? There have been vacancies in the constitutional courts and high courts in Eastern Cape, KwaZulu-Natal, Western Cape, and Gauteng since October 2024. Chairperson, we appreciate the effort made to roll out court online. How is the department going to ensure the securitization of court online system and averting of cyber threats? Lastly, Chair, the Office of the Chief Justice is currently undercapacitated, and the committee has been consistently raising concern about budget cuts. The undercapacitation has an impact on the morale and the wellness of the staff, which may lead to an even higher staff turnover. What is the department doing in addressing matters of wellness and morals of the staff? Secondly, Chair, regarding bursaries for employees, 60 bursaries were allocated in 2023-2024. Currently, there is no allocation that has been done. And since that allocation, when you check the current budget, I don't see anything that speaks to the budget for the employees in the OCJ. Thanks, Chair.
Thank you very much, Honorable Mtawung.
Chairperson,
Honorable Mshala?
it seems like I was cut off.
No, you
I
were
don't know.
not. We heard you until you concluded, but it looks like it's you who was not hearing us on the other side. Because when you talk to us, we can hear you, but you can't hear us when we respond.
Oh, okay. No, thank you.
So quick issues, quick two things from my side is that the current adopted fiscal framework doesn't have the then envisaged 2% VAT, 0.5% VAT. How has that impacted the budget of the OCJ, if it has? The issue with the leasing of vehicles of judges. We support the fact that you are doing away with leasing because it gets more expensive than actually acquiring the vehicles for the use of judges. So to what extent do you think that you'll be able to have eradicated the leasing arrangement in the year 2025, 2026? Thank you very much. Minister, you may start.
Thank you, Chair. Let me allow the team to start and then I will come at the end. In terms of that, I think the CFO will respond to the financial matters. And then there are issues that from the departmental point of view, will need colleagues to answer, especially on infrastructure. I'm just looking if Tabiso is here. I don't see Tabiso. I don't see Muhalaba DG. You'll have to come in and respond to those, DG Mashaban, because as we talk about shared services, those things are in the department in support of the judiciary. And as we embark on those processes, I will request the colleagues in the department to come in and close the gap on the issues that relates to the work that they are doing, that is sitting in the department instead of in the what is it called, in the OCJ. So let's proceed in that way. CFO, and I'll start with the team at the OCJ and then come to the team in the department.
That's fine. That's in order. Let's start with the acting SG.
We are unmuted. Thank you, Chair. And thank you, members, for the questions. I will also ask the CFO and CIO to assist me with their responses. If I go through my notes, the Durban High Court is currently at a decanting site in Durban whilst the reparations are busy. Infrastructure is part of our shared services currently. Must admit that on Saturday, I had a discussion with the DG of DPWI, and it seems that due to budget constraints, our occupation will be prolonged, but I'm waiting for a confirmation in writing. So yes, members.
Acting SG. Also,
Yes.
the question included a part that says it's in which stage now? It's what percentage of completion is it in currently?
I will rely heavily on DOJ to give me the percentage. What the DG has confirmed is that finalization will only be in June 2026. So initially we were told November 2025. That was extended to April. It has now been confirmed to be June 2026. But the percentage, I'll rely on my counterpart in Justice. Thank you, Chair.
Okay.
Then I want to confirm the law researchers. I recall during our oversight visit in Durban, it was mentioned by the honourable member, and we have confirmed that our ratio of law researchers to judges is currently not acceptable. But thanks to the budget injection, we have managed to reprioritize funds so that we have created additional law researchers in our Supreme Court of Appeal. The ratio there will then be 2 judges per law researcher. The ideal is actually a 1-on-1. Our judges secretary post were also created for our Labour Appeal Court that we could not support in the previous financial year. Slowly but surely, we will plan in accordance with our available budget to enhance the law researchers in the next 2 years in all courts. I'll leave the training of judges to Dr. G. I saw she is online. If we go to fraud and corruption at Mthatha. Now, the Office of the Chief Justice has a zero policy towards fraud and corruption. After receiving allegations, anonymous allegations of fraud and corruption, a thorough investigation was lodged by our forensic unit, and close cooperation has been received from law enforcement authorities as well. In addition, the Chief Justice and our management team has visited the Mthatha Court with the AJP, and hence we've decided to expedite the rollout of court online. We have also strengthened the internal control measures. But these allegations were not yet substantiated. Hence, no consequence management could follow until substantiation of those allegations. A similar matter was also reported recently in the media of Pretoria High Court, and because of the close cooperation and collaboration with law enforcement agencies, those allegations were substantiated and 3 officials were put on precautionary suspension while the investigation is concluded. We are actively working with our forensic unit, and I may hand over to Ms. McKeezy just to highlight our efforts in curbing corruption and fraud. In Mthatha, we've also then started with lifestyle audits, and she can elaborate on that. Anything that I have left out, colleagues, CFO, if you can take the vehicles, Ms. Mckeezy, if you want to highlight on the fraud and corruption, CIO, is there anything you would like to add on food online and cyber security and wellness? DDG? Training and wellness, Ms. Mpe. Okay, CFO, you might proceed. With your permission, Chairperson, I almost thought you Chief Justice. Apologies.
Thank you, Chair and honorable members. On the issue, Chair, of budget, as the SG and the ministers indicated, we don't cover budget for infrastructure because the budget is with DOJ and some of the budget is with DPWI. But we've been having engagement since the meeting with the judiciary and the executive then we are in a process with Treasury, DOJ and OCJ to look into the fact that the budget for infrastructure and security must now be transferred to the OCJ. We've been having engagement of which we then also engage in Treasury because DOJ has indicated that even if the budget will come to OCJ, there's no budget for the resources. So we are still working on that budget. On the issue of training, Chair, we have a budget for training of support. It's been allocated because last year it was also part of the WSP was part of one of our targets on the APP. So we have budgeted for that. Even the bursaries we have issued, there are budget for the bursary that has been issued. So I think the communication will be issued for officials to apply again for this new financial year. On the issue of the budget for vulnerable and disability officials like outreach, we don't have budget for that. But what we then touched on during the presentation for communication, we indicated the fact that we as OCJ now we need to have a budget where we do outreach for OCJ because we've identified that some of the people they don't know the mandate of OCJ, so it will assist to do outreach for OCJ to then give the community the understanding of how the OCJ function. The budget for independent and monitoring of what we do, our budget is aligned with our targets on the APP. We make sure that our budget is aligned with our targets. So it's outlined on the APP, also on our operational plans. So we do our budget in line with that, in line also with our demand plans. Our demand plans, when we prepare them, we make sure our demand plans are aligned also with the APP, also with our operational plans, so that when we monitor the budget to ensure that the budget sufficient to to ensure that we achieve our target. On the listing of vehicles, Chair, we anticipate that because now we are starting the process and the procurement process also, it's a tedious exercise which makes this procurement very challenging. For example, you find that some of the vehicles that the judges will require, they are not under the RT57, which the contract has been given by National Treasury. And when you then procure outside the RT57 and you are participating on that, it's a challenge when you find that the vehicles are not part of that. But we have done some deviations memos where we now want to cover the process where the vehicles are not covered through the RT57 from National Treasury to ensure that we speed up the process. So, Chair, I must say we can say not, maybe it's even less than 10% that will cover, because most of the judges, they've just renewed their vehicles like last year. So most of their vehicles, they are still within 4 years. So currently, I must say, Chair, we only received less than 10 vehicles requests that we are going to do through the outright purchases. So I can say maybe by the end of the financial year, we might say 20%, 30% that we'll be able to procure through the outright purchase, while we are still monitoring and communicating with the relevant courts to indicate that if a judge then is about to their vehicles is about to come to the end of the lifespan or 160 Ks, then they must inform us so that we start a procurement. The other thing that we presented to the judges is the fact that some judges, they don't want to replace. So if a judge doesn't want to replace, then we can engage, it's either one of these G Fleet or GMT, the garages, to say maybe we can procure that vehicle from them and it will be more cheaper in that way also. So that's from my side, Chair. Thank you.
If you could proceed.
Okay. Good morning, Chair, and morning, Minister, Honorable Deputy Minister, and all honorable members of Parliament. I'm just going to give responses on issues of anti-corruption as to what is the direction or the policy direction of the OCJ in terms of that. I would start by saying that the OCJ has a comprehensive anti-corruption and ethics policy framework that we're operating with, and it encompasses everything, including prevention, detection, investigation, and resolution. By resolution, meaning that it covers all the consequence management processes. And I'm talking to this because there's an honorable member who have asked around what do we do, what is our consequence management. What I can say on that is that after we've investigated and substantiated the allegations, if there are members or staff members that are involved internally, what would proceed thereafter would be consequence management, which would be disciplinary. And then if there are criminal elements, a case will be opened. And we also work together with the law enforcement agencies, your SAPS and DPCI, and there are investigations that we currently, or we are working with them on matters that have been investigated. And in terms of witness protection, currently what we have is that our anti-corruption policy framework involves lodging of cases where the complainants or the complaints can be lodged formally and anonymously as well, and that internally is treated as anonymous. And we also follow the DPSA guidelines in terms of protecting those that lodge complaints, and majority of our cases comes through those measures, including the National Anti-Corruption hotline that is managed nationally. So we have that in place currently. And in terms of the progress on Tata, Chair, allow me to talk to it without compromising the case. We can actually give members assurance that from day one when we received the complaints, we did not shelve it. There's measures that were put in place, and the case is currently under investigation, whereby some of those that were alleged in those things are being investigated together with the law enforcement agencies. And I would maybe leave it at that without outlining what is happening, but then we are investigating the case. I think what maybe as well would be a challenge, and I think it's flagged in our APP, is the resources to investigate, and that's the whole reason why we have 75% cases. We aim for 75% cases, and I'm going to talk to the 2024-25 as the member has asked the question around what we have investigated and what was reported to us. We do have challenges in terms of resources. However, we do our best to ensure that all the cases that are reported through all the mechanisms that we utilize are investigated thoroughly. And in terms of what we have investigated, we received 35 matters last year through all the measures that we operate internally. And we can safely say we have investigated and reported on 33 matters. And we have, 32 matters, and we have taken over or rolled over 3 matters. And I think that's where the 75% comes in, because we recognize that the resources do not allow us to investigate all the matters as we receive them. So I'll stop at that, Chair. Thank you.
Thank you, Ms. McKeezy. Before we hand over to the CIO, I've just noted 2 questions that the committee has asked, and the one relates to the 3 former colleagues. Now, I've already mentioned the matter had a civil and as well as a criminal side. The civil side has been concluded. The criminal side is still in court, and beginning of July, we've received notification that the trial will proceed beginning 3rd of July, if I'm correct. Chairperson and members, then various questions were also raised with regard to judicial performance. I must just highlight again to the committee that judicial performance was delineated, the function was delineated from the Office of the Chief Justice in 2018 already. Apart from Section 8 of the Superior Courts Act, that also provides that the Chief Justice is the head of the judiciary and responsible for setting standards and norms, which will be monitored. The judiciary reports to the public through their annual report, as alluded to earlier. We will have a Judiciary Day later this year, where the next report will be released. And that report includes then matters such as backlogs, a reserved judgment report has now recently been published again, and that is a quarterly report that we are also monitoring in support of the judiciary. So without further ado, and in the interest of time, CIO, if you can address the cybercrime issue, please. Thank you.
Thank you. Good morning, Minister, Deputy Minister, Chairperson, and the members of the Portfolio Committee. In response to the issue of how do we protect the cotton line system against the cyber threats, I must indicate that firstly, we have a cybersecurity program, which is very much in line and compliant to the DPSA cybersecurity framework. It is funded, and then we have systems that are monitoring all our systems, both internally and also the cotton line system. The cotton line system is actually hosted on the cloud, very secured. And I must also indicate that we're monitoring it on a daily basis as well. CETA is supporting the system, including as well the infrastructure and security. And we basically do the patch or maintenance of our systems, both the ones that are internal and also hosted on the clouds like Coronline on a monthly basis. I must also indicate that we do the continuous vulnerability assessment. This is required by the DPSA, which is the 2 vulnerability assessments that are done in a financial year. And finally, with this system as well, we also did the penetration testing, which was done by CETA, which is also called the ethical hacking. This is just to actually confirm at a certain point whether the system is hackable or not. But I must indicate that the system is highly protected. However, and CETA as well is actually supporting the system and also together with Microsoft on the Microsoft Cloud platform. Thank you.
Ms. Mpe, Wellness.
Thank you, Chair. Honorable Minister, Deputy Minister, and members of the Portfolio Committee, I'll respond on the issue of employee wellness programs. In the past financial years, we had projected 18 wellness programs, and we achieved 46 employee wellness programs due to the increased demand for wellness programs. And in the 24-25 financial year, we had 1,530 employees who benefited from the employee wellness program. And then with regards to bursaries, for the 23-24 financial year, we had 146 employees participating in the bursary program. And in the past financial year, we had 117 employees participating in the bursary program. Thank you, Chair.
Thank you, Ms. Mpe. Chair, then finally, Dr. G is online. If I may hand over for Sajay training. Dr. G.
Okay, good morning. Thank you, ASG, and morning to the Minister, Deputy Minister, and honorable members of Parliament. The training on ethics and morals, it's a part of our programs on a yearly basis. The judges are trained for a period of a week every year because the recess period in January was reduced, I think about 3 years ago. So we only have a week-long training for judges in July. Like for this year, it's going to be the 7th to the 11th. And on that particular program, we've got judicial etiquette and conduct, AI and ethics. In 2024, we had judicial independence and accountability. 2023, we have judicial ethics. So we normally bring retired judges to come and present on those topics. And we try all our best when we put together the program that we deal with pertinent issues, but also soft issues like judicial wellness. It features on our program for the last 3 years. Yeah, I think that is all because the question was around the morals and ethics. Thank you, Chair. Thank you, ASG.
Thank you, Minister. I think the team of the department must answer the relevant questions now.
Yes, I see the doc's notepad is here, but I don't see anyone else. So DG, I'll give it to you from the department on the issues that relates to support services, the network, internet base as well, the issues that relates to infrastructure in terms of the plans. DG? Justice, where's the DG? Hey, you see these online meetings. My apologies, Chair. Let me take the responses and not wait the time I'll deal with my team. You see, that's why sometimes some of us don't like this online meeting. You get left with gadgets and no people. It becomes a difficulty. Chair, just to highlight, and let me take through the members around the issue of infrastructure. I'll start there because I think it's the major issue that everybody has been raising. When we look at the infrastructure, so we've looked at, and I agree with the members that, let me start by first, or maybe I should have allowed the DM so that I close. But let me allow the DM, my apologies, I thought the DG will deal with technical issues, and then I'll close and respond even to the issues that the department would have responded to because I am familiar with them. DM, let me allow you so that I don't speak before you.
No. Yeah, let's also be mindful of time.
Of time as well. Okay.
And also that I don't speak after you. No, Minister, thank you very much. I think just 3 very quick points. The first is, again, just to thank all of the honourable members for their questions and inputs. They are very, very much valued and appreciated. Secondly, we would just want to share the concern expressed by the Honourable Nomvalo regarding the sometimes seemingly inordinate delays in the finalization of judicial misconduct matters, sometimes going over a decade, and the fact that they continue earning salaries even whilst suspended pending impeachment proceedings before Parliament. Then the Honourable Steve Swart, I think, made a very, very thoughtful contribution on the question of judicial independence and a judiciary-led administration model. I think correctly he pointed out that the Office of the Chief Justice was established around 2009, 2010, with the intention that that should serve as a stepping stone to that fully fledged independent court administration model. He lamented the delays in bringing that to finality, and I think it's a delay that we share, or a lamentation that we share. But I think he went on to highlight the somewhat intricate and complex constitutional imperatives that are at play in this question about how we strike the appropriate balance between the roles, functions, powers, and responsibilities of the executive, the legislature, and the judiciary. The outcome of such a model obviously must be to strengthen the independence of the judiciary, but at the same time, we must assert and provide and cater for the role of Parliament in exercising oversight and on behalf of the people who elect the representatives who sit in Parliament. And I think the challenge is how to craft a model that does that in appropriate fashion. I think the acting SG also, in addressing the issue of judicial performance, highlighted the fact that at the moment, the Chief Justice on Judiciary Day tables a report that deals very comprehensively with matters of judicial performance, the functioning of our courts. I think the question is, how does that report come before Parliament so that the elected representatives of the people can engage with it and engage the judiciary, but also do so in a way that respects the dignity, the status, and the independence of the judiciary. And I think that, in a small way, has also contributed to some of the delays in finalizing this model. But I think, as the Minister indicated at the outset, very clear timeframes have been established, and I think there's absolute commitment from the executive to bring that process to finality. Minister, I thank you, and Chairperson, I thank you, and the committee as well.
Thank you. Minister, close it down.
Thank you very much, Chair. Let me first, so that we don't waste time, what I'm going to do, I'm going to send you, Chair, just maybe 2 slides that highlights the courts that will be upgraded this year, which areas, and the ones that are going to do R&R. I think that will be easier for us so that we close the issue of infrastructure. And as I said, where the gaps are, we've identified about 539 courts. So those 2 slides will be in detail, including the 2 slides that relates to security, what we need in the courts and what we are having a shortfall of. I must say, Chair, the attitude of the Minister of Finance in relation to the OCJ is the same with all of us. And that's why Honorable Swart correctly identified that sentence in the budget speech in February, because we had identified that we might not be able to incorporate everything that is needed at the time of the delivery of the budget after our conversation. But we said that in the medium term, as we work towards the processes, then we'll be able to allocate such. And then within myself as well with the team, we'll work on the transitional method in terms of issues of transition. to the point I said long-term commitments by the department should not be made, because one of the issues that the OCJ, the judiciary, bemoaned was lack of consultation on decisions that the executive is taking. So the sentiments that you are raising here, we've acknowledged. The president has given us instructions as the executive on what needs to be done and how. So within 2 months, Chair will be ready to come and present overall plan to say this is where we are going, so that we do not seem like it's a lip service. It's something that we are not committed to, especially with the experience of the past. So I just want to assure you on that one. And then again, the issue, I think we must correct members, because sometimes if we leave things unchallenged, Chair, it could be assumed as correct. There isn't a political intervention or interference from the executive to the judiciary, that I can assure you. Neither from the president nor from myself as the executive authority responsible for this portfolio. We've always, what we maintain is that we give them support and allow them to do their work. They make their decisions and they can confirm that if you interact with them. And we want to encourage that. So I think major issues have been covered. Issues of trial dates, I think as well, Chair, it might be important because there's court challenges around what the JP Mlambo has put in terms of mandatory mediation. And some people are saying it's not in the interest. So it might be important interest of the public, which I think it's actually helping us. When you look at your medical, when you look at your RAF, because those things, if you look at how court runs in High Court, you find that there are 19 of them. On the day of sitting of court, where it has clocked the court, you find that when you look at it, all of them have gone to the judge to say, no, withdraw, we've settled. So you find it lasts about an hour, whereas the court has been booked for a full day to hear those matters. Now you find that it's a waste of time because we have not scheduled other matters. So I do think that the portfolio committee will have to look at this matter independently, maybe perhaps give an opinion in its impact. But from where I'm sitting as the minister, I do think that is helpful. It will allow us to be able to fast track some of the issues. Actually, I'm starting to get in other courts where they are saying there is a need to look at some of this mandatory mediation and guidelines to other provinces. The last point I want to speak to is utilization of digital platforms. So the current regulations does allow for virtual hearing of cases as part of fast tracking the processes. For example, where there are reminders, it's a bail appearance and all those things. As part of reducing the cost, we think that it's important for those to be considered. We did have this discussion in our meeting with the judiciary, and there were quite a number of the judge presidents that they were going to socialize with others in terms of the representative, to socialize with the full component of the judge presidents, to look at ways where there's high risk cases. For example, when you look at in Western Cape, you find that Paulsmoor has a courtroom that can be utilized for a case that we think is high risk, that can risk the judicial officers and the witnesses to be heard in that. So it's work that will be in progress. So there's broader reforms that are being done, and there's a lot of work that is being done. And we do appreciate, because when we met with the judicial, we took most of the ministers' chair. Minister of Finance have met with the judicial, we brought him in. Minister of Public Works and Infrastructure was not there, but the deputy was able to come. He delegated the deputy to come. And we've been dealing with the Minister of Public Service and Administration, helpful in the process. So we have come out as the executive in this administration as well, together with our teams, to support the Department of Justice, OCJ, but more broadly in ensuring that we do not hamper on what is envisaged in the Constitution. So with that, thank you very much, Chair, for the support. And I might not have said, because colleagues have answered quite a number of them issues, but I appreciate that all of us are on the same page on what needs to happen with the sector, what needs to happen with the judiciary, but also the process. So we'll consistently account to you, Chair, and report to you as we navigate the process. And we'll also ask for your guidance and help in areas where we are battling. Thank you very much.
Thank you very much, Minister. Thank you very much, TM, for that concise briefing. Thank you very much to the officials of OCJ led by the Acting Secretary General, to all the officials of the department that were here, including those that were here but who couldn't speak when they were called to answer questions. Members, thank you very much. We are pressed with time. The Human Rights Commission has been awaiting us. Would have initially thought that will take them around 11 or the latest half 11. We are now 5 minutes to 12, so I won't be doing any closing remarks in respect of what has been presented, but I think it is our general view that let's continue to do the work that we are obligated to do. And I think we note most importantly the online rolling system, the court online rolling system that you would have come at some time to Parliament to come and present on it. We know we've seen, I think we've seen you went to Mahikeng as well, if I'm not mistaken. You went to Mtata as well for a live launching. I think we appreciate and we believe that it will not only save costs, but it will also grant extra access to justice, because it is our belief that we need to be very deliberate on access to courts and access to justice. And access to courts and access to justice are correlative aspects. And part of what you must also consider is the fact that how do we then expand access to high courts? Because you'll remember that, for example, if you go to KwaZulu-Natal, the example Nomval was making, it may seem expensive to access the high court system. In the Eastern Cape, a person whose jurisdiction of the High Court is in the Makhanda High Court comes from as far as Alwal North, as far as Stakespruit and stuff. And that's serious distance to travel. So if you can expand on them, establishing some, even if it's periodical sittings of the High Court in one of the magistrate courts where we've got necessary facilities to get at least one or two courtrooms, 2 or 3 days a week to have an operation of the High Court in the magistrate court precinct, so that some of the not so critical matters can be adjudicated or can be processed in those periodical courts. I think a lot of issues have been touched, including the issue of the Judicial Handbook, the Sajay Bill. We note them. We note particularly the decision to do away with the leasing vehicles for judges, because leasing is more expensive. We've always been a committee that is firm on saying we better try the best to solicit an infrastructure that will belong to government instead of using private sector to solicit the tools of trade and stuff. We had always advocated for even the formal residential houses of judges. It is very much best when we're able to get close to DPWI to help us get some of those. They are not in use for purposes of renovation. We renovate them, then our judges are able to stay there and stuff. So we encourage that kind of a commitment to ensure that the issues relating to leasing are all kept. We have a standing annual meeting with the judiciary led by the Chief Justice, as Mr. Swart was saying, on matters of mutual interest. I think some of the issues that would have been raised in this meeting will be able to deal them properly when we have that meeting with the judiciary. So members, that marks the end of our meeting, and marks the end of the item, not of the meeting. So we'll release OCJ, then we'll remain. Minister, we are remaining. boss.
No, Chair, I won't be remaining on this one. It's DM who will be remaining.
So we are running away when there are more problems.
No.
Okay, no, that's
No,
fine.
it's delegation of duties as well. And I know that my DM is happy to
Okay,
proceed.
no, that's fine. That's fine.
I
We'll
have a
excuse
matter that I
We'll
must sort out urgently. Otherwise, I'm going to be convicted of contempt of court without knowing. So my apologies, Chair. I have
No, that's fine. Committee Secretary, is the commission in the platform?
Thank you, Chair. May we be excused?
Yes, you are excused, acting as chair.
Thank you so much. And thank you to the members as well.
Thank you.
Chair, the commission is in attendance.
Good afternoon, Chair.
Good afternoon, Honorable Chairperson.
We only see the top. We only see the top of your heads. We can't see you. There's a cheese scope and a weave that we saw. Yeah, then we can see you. Then we see you.
Can you see me, Chairperson?
Yes, and you are audible. And you are audible. That's fine. Hold on like that. Members will take only 30 minutes for their presentation, then we'll interact with it. Yeah, then I think around 1 or slightly after 1 would be done, hopefully. Chair, good afternoon. Apologies would have been held up with the Office of the Chief Justice on the same item. So we'll take you, you'll introduce those that which you are with in the boardroom. Then we'll introduce the report. Then I'm sure your secretariat, the commission secretariat, would be dealing with the nitty-gritties and the specifics of your APP and budget. Then members will interact with it. But we want to plead with you if you can try do the presentation within a period of 30 minutes. We know we've given the Office of the Chief Justice 30 minutes and they've been able to adhere to that. And you must be jealous that they must not do better than you. So, Chair, the platform is yours. You'll introduce your team, then proceed.
Good afternoon, Honorable Chairperson, Honorable members of the Portfolio Committee, and DM. Well, on behalf of the South African Human Rights Commission, I extend our sincere appreciation for this opportunity to present our strategic plan 2025-2030 annual performance plan for the 2025-26 financial year and the supporting budget.
Oh, sorry, sorry, Chair. Sorry, please. DM will take you immediately after their presentation.
Yes, Chairperson, I think that is also correct in principle, given that the Human Rights Commission is an independent Chapter 9 institution. So we are not introducing them, but we will follow and add what we are doing to support them. Thank you.
All right, sure.
Chairperson and honorable members, I'm joined by Commissioner Mandringosi, whose focal area is equality, anti-racism and education, by Commissioner Mokasha, pro-human rights budgeting, business and human rights, and health. Commissioner Ngumbele, migration, human settlements and climate justice. Commissioner Kwinana, civil and political rights, children and justice. Commissioner Bosov, socioeconomic rights with the emphasis on water and sanitation. And the new commissioner that's still to be announced, we have allocated persons with disabilities, older persons, and social security, which was done previously by Commissioner Yunana. And then Commissioner Tudi, food sovereignty, land, and national preventive mechanisms. Alongside our acting Chief Executive Officer, Advocate Crystal Pillay, Chief Financial Officer, Dr. Talifani Ubana, Acting Head of the Commissioner's Program, Dr. Kwanele Pagati, and members of the Secretariat. This engagement represents more than a statutory obligation. It's a strategic accountability platform that reflects our shared constitutional commitment to building a democratic state rooted in human dignity, equality, and accountability. It also allows for critical oversight as the Commission positions itself for a new cycle of performance and impact. The Commission's strategic plan for 2025 to 2030 is anchored in the vision of an equal society where human dignity is restored and human rights are respected. Over the next 5 years, our focus is to deepen the impact of the Commission through enhanced stakeholder engagement, expanding human rights awareness, and ensuring compliance with the national and international human rights obligation. We are particularly committed to improving the accessibility of the Commission's service, ensuring that all people, particularly vulnerable and marginalized groups, have effective access to justice and redress for human rights violations. In order to deliver on the above, the Commission has identified 5 strategic outcomes, each supported by measurable indicators and 5-year targets, which the acting CEO and CFO will talk to. This strategic plan is firmly aligned with the goals of the National Development Plan and our commitment to the international and regional obligations. We are confident that through strategic partnerships, expanded community outreach, and sustained participation in regional and global human rights mechanisms, the South African Human Rights Commission will continue to serve as a critical enabler of transformation and accountability in South Africa. The acting CEO and the Chief Financial Officer will also present the annual performance plan for 2026 financial, which operationalizes the first year of the strategy. However, I must take the opportunity to raise a matter of strategic importance. The Commission continues to carry unfunded statutory and international obligations, notably our mandates as the National Preventive Mechanism under the optional protocol to the Convention Against Torture, OPCAT, and the independent monitoring mechanism under the Convention on the Rights of the Person with Disabilities and Child Rights Convention. These mandates are constitutionally and internationally grounded and need to be financially supported. We urge this portfolio committee to continue advocating for the necessary alignment of mandates and resources in line with obligations as the constitutional democracy and a treaty signatory. This year, we also mark a significant milestone, 30 years since the establishment of the South African Human Rights Commission in October 1995. This movement invites us to reflect on our journey, renew our commitment, reimagine the role of the Commission for the next generation. In conclusion, we reaffirm our commitment to transparency, ethical governance, and measurable impact. We remain open to the constructive dialogue and welcome the support and insights. With your permission, Honourable Chairperson, I now invite Advocate Crystal Pillay, who will lead the presentation of the strategic plan and annual performance plan with the CFO, Dr. Kubani. Thank you, Chairperson.
Thank you, Chair. Dr. Pillay.
Thank you, Chairperson, Honourable Chairperson of the Portfolio Committee and Honourable members of the committee. Good morning. And once again, thank you for the opportunity to appear before you today. Let me reiterate, as indicated by the Chairperson, that it is indeed a privilege for us to present the Commission's strategic plan, our annual performance plan, and the budget allocation for the 25-26 financial year. The 25-26 financial year, Chairperson, the planning cycle comes at a time when the institution has made significant strides in stabilizing its operations. The past year has been marked by deepening socioeconomic challenges, including persistent inequality, rising levels of poverty, service delivery failures, and threats to social cohesion in the country, And these issues have placed an increased demand on the Commission to ensure that it protects the rights of vulnerable and marginalized communities. Against this backdrop, Chairperson, our work continues to be guided by our constitutional mandate in Section 184 of the Constitution. Although, Chairperson, we must be mindful that while we face a growing demand on the Commission, the budget of the Commission remains a concern as the Commission operates with a level of financial constraints. However, you will hear a bit more about this in the presentation.
On a point of order. Chairperson.
Hold on, Ms. Pillay. Honorable Mhlala.
Is it possible, monument, is it
Honorable
possible for
Mhlala.
Yes, I'm saying, I'm greeting. I'm asking if is it possible for them to flight the presentation on the screen.
Okay.
Thank you.
Thank you, Honorable Mhlala. Committee Secretary, do we have the co-hosting rights to flight the presentation?
Chairperson, I've given them the rights.
Okay.
Chairperson, if I could come in, please, just to indicate we will flight the presentation. However, my comments are just an introduction to the presentation at this stage. The presentation will be done by the CFO.
Yeah, the last time we came in that boardroom, it had proper facilities for flighting.
Yes.
Bear with us for a second, Chair. Yeah, bear with us for a second.
No, I was saying the last time we came to that boardroom, it had proper facilities for flighting the document.
Yes.
Unless they are no longer working, Chair.
That's working, Chairperson. Give us just 1 second. We'll check.
Yeah, there it is. There it is. You can proceed, Ms. Pillay.
Thank you, Chair. As I've indicated, Chair, if you will allow me just to introduce the presentation with a few introductory remarks, and I will hand over through you to the CFO to take us through what is being flighted on the screen at the moment. Chair, I thought it was important for us just to mention that it was always clear to the Commission that we needed to take steps to stabilize the organization. And sorry, Chair, can you not hear us?
Can you hear us?
We can hear you, but the presentation on getting. Yes, we can hear you.
Maybe perhaps.
Can you hear us on the other side?
Yes, Chairperson. We just backing just to on our side we see it, but the presentation being flagged, but I don't know whether you can see it.
Yes, the presentation is flighted now, but it keeps on getting off the screen when you start talking.
No, Chair, let me assist. I think that she said she will first make introductory remarks before she can flight the presentation. So it's I think we can accept that.
Yeah, introductory remarks are a presentation as well, but yeah, due to circumstances, we can forgive them. Okay, you can proceed, Ms. Pillay.
Okay, thank you, Chair.
Proceed, Ms. Pillay. Then what you'll do when the CFO comes, then we'll retake it to the screen again.
Yes, we're just going to try and use the CFO's laptop now so that he can flight the presentation. But let me quickly go on. We wanted to make it clear, Chair, that it was important for us to take steps to stabilize the organization and build a culture of performance, accountability, and service excellence. And some of the notable areas of progress that we thought we would mention today, but of course there are a number of them. However, I will zone in on our protection mandate and the investigative impact that we have had by concluding several high-profile investigations, particularly in relation to access to basic services, education, rights, anti-discrimination, and unlawful evictions. The Commission also uses strategic litigation to push systemic change, particularly in rural and underserved communities, and this must also be a notable demonstration of our intervention on oversight in advancing constitutional rights. Some good news for the Commission that we thought we would share with the committee today is just this week, the Commission obtained an order against the Masilonyana municipality at the Lejwelleputsa district to immediately take necessary steps to ensure there is supply of safe drinking water to residents in Windberg in the Free State. And the Commission reports this as a success because the court further also ordered COPTA, MEC, and Minister of Water and Sanitation cited as respondents to comply with their constitutional and statutory duties, which encompasses to support and strengthen the ability of the municipality to provide safe drinking water to residents. We thought that the committee may also be aware that we are currently involved in other strategic litigation matters, such as specifically the Agrodat data case, where we are currently in the Apex Court seeking relief from the court to pronounce on the legal status of the recommendations and directives of the Commission. The AfriForum case as well, where we are in the Supreme Court of Appeal, appealing the court's judgment against the Commission and its findings relating to the binding nature of the recommendations of the Commission. Looking ahead, Chairperson, this planning cycle marks an important turning point for the Commission. Over the past year, but more specifically the last 2 quarters of the last financial year, the Human Rights Commission has made significant progress in moving from a context of operational instability to one of growing stability, accountability, and performance. We have implemented focused interventions to rebuild systems, enhance coordination, improve compliance, and strengthen our ability to deliver on our constitutional mandate. Our strategic plan, you will see, reflects the institution's medium-term vision and priorities aligned with the national development objectives and our very own legislative mandate. The APP, on the other hand, will outline the concrete outputs and activities we intend to pursue over the next financial year to bring that strategic vision to life. While developing these plans, it was important to remind ourselves of the institutional performance from which we have emerged in the previous financial year. The Commission concluded the 24-25 financial year on a positive trajectory with notable improvements in quarterly performance, particularly at Q4, which recorded 92% achievement in our plan targets. This marked a significant recovery for the Commission from 62.5% performance in the Q3 cycle, reflecting enhanced implementation, coordination, and responsiveness across programs. The Commission saw an overall annual performance for the 24-25 financial year at 85%. Despite a few implementation challenges, the Commission made significant progress in delivering on its mandate. Overall, the Commission made meaningful progress in fulfilling its mandate and was well positioned to transition into this new strategic planning cycle 2025 to 2030. We developed our 5-year strategic plan, Chairperson, and the APP targets with improved integration between programs and integrated planning with commissioners. The integrated planning was based on the one commission, one plan principle. Strategic and operational planning processes were aligned to enable better resource allocation, monitoring, and reporting, and priority focus areas of commissioners were embedded into institutional programs. Roles, of course, were also clarified in terms of strategic oversight from commissioners versus operational delivery from Secretariat. Key priorities for 25-26 financial year will include, and you will also take note from the presentation as well, enhancing access to justice, expanding the reach and visibility of the Commission, investing in organizational capacity, but more specifically including the filling of critical posts, attracting and retaining specialists, where performance in certain areas have been in high demand, such as, for example, our legal services division, monitoring and research, and human resources. We are looking at implementing an improved human resources development framework. Further, ensuring sound financial management and full compliance with the PFMA and delivering improved value for money through disciplined budget execution and efficient use of public funds. And most importantly, demonstrating measurable impact in the lives of the people that we serve. Our budget allocation, Chair, which we will be elaborating on shortly, has been carefully aligned with these strategic priorities, ensuring that it contributes meaningfully to outcomes that matter to the country. Chairperson, we remain mindful of the fiscal pressures facing the Commission, or facing the state, should I say, but we also wish to highlight the resource constraints that continue to affect our ability to fulfill the scope of our mandate, particularly in our provincial offices. Chairperson and honorable members, we look forward to firstly engage the committee on how we will translate these plans and allocation into measurable improvements in the lives of the people and we are mandated to serve. And secondly, to your guidance, your oversight and your support in ensuring that the Commission is fully equipped to discharge its duties in the service of the people. Through you, Chairperson, I would like to hand over to the CFO, Dr. Talipani Kobana, to take us through the presentation itself, the strategic plan 25 to 30, the APP for this financial year, and the budget allocation for the 26th financial year. Thank you, Chair.
Thank you, CFO. Please proceed.
Honorable Chairperson, honorable members of the Portfolio Committee, Deputy Minister, DOJ, the Chairperson of the Human Rights Commission, commissioners, and members of the Secretariat present here and on the platforms. I will then take us through the presentation as per the invite of the Portfolio Committee, which indicated that we are required to present on the strategy 2025-2030, as well as the annual performance plan for 2025-2026 financial year, which includes the budget. I must indicate that the presentation is also structured in the same manner, but I will start by reiterating the mandate and the obligations of the Commission. We consider it very important.
CFO.
Chairperson?
Just leave the mandate. You can skip the mandate and go to the actual presentation.
That is in order, Chair. In that case, Chair, I will go straight to the strategic presentation of the strategic plan 2025-2030. This strategic plan indeed is presented here, setting a medium to long-term vision and a roadmap for the Commission as it seeks to execute its mandate. The strategic plan is anchored by the impact statement, which defines its desired long-term societal change. And as part of this strategy, we have got 5 strategic outcomes that reflect the core business of the work of the Commission. I must indicate that these are further broken down into outcome indicators, which are measurable over the next 5 years. We confirm and reiterate that this strategic plan and the APP, they are aligned to the National Development Plan priorities, the MTDP, as well as all commitments to international and regional commitments. As I indicated, Chairperson and members of the Portfolio Committee, the impact statement of the strategy of the Commission for the next 5-year period is equal society where human dignity is restored and human rights are respected. this statement is what we will use to measure ourselves if over the next 5 years we have really transformed the lives of the people. The outcomes that we have in this case are 5. I will basically indicate that the first outcome is effective and efficient administrative services, which will be measured by improved audit opinion. We have fortunately been able to retain an unqualified audit over the last 5 years, and the intention is that in the next 5 years, we would like to then move into clean audit. The second outcome is increased reach and enhanced awareness. In this case, our focus and our measure of how we would have performed over the next 5 years will be the number of promotional activities that the Commission will conduct, which we estimate that 2,250 will be what we shall have executed at the end of 2030. In terms of the third outcome, which is redress provided for human rights violation through effective legal intervention, we must indicate that in this case, we would like to measure ourselves by percentage of human rights violation matters that shall have been finalized. That means on an annual basis and over the next 5-year period, we intend to ensure that 80% of all issues that are raised or registered with the Commission are finalized. The fourth outcome is observance of the implementation and compliance by the state on human rights obligations. In this case, we will definitely be issuing 15 reports on observance of human rights over the next 5 years. The last outcome is compliance with human rights obligations and active participation in international fora. In this case, again, we intend to issue 5 international and regional obligations reports. As I then move on, how will we measure this over the 2025-2026 financial year, which is an APP which we use to break down in a measurable way what are the output levels, indicators, and the targets for the financial year. I will then start presenting this based on programs that we have. So the first program where outcome 1 is located, we have got 2 output indicators, which we, amongst others, include improved audit outcome. And we've indicated that by 2030, we intend to have achieved a clean audit, but for 2025-26, we are saying unqualified audit with 50% reduction for audit findings. The Commission has embraced digital journey or digitalization, and as part of making sure that our work embraces artificial intelligence, we are refining or we are enhancing our ICT systems. And in this case, we intend to implement about 3 modules that will assist the Commission in terms of both enhancing the reach, but also improving effectiveness of the work of the Commission. This program, Chairperson and members of the Portfolio Committee, we can see that over the last financial years, it had been spending in between 80 and 87 million, with 2023-24, where the Commission had spent 86 million. And for 2025-26, we are projecting that for that particular financial year, we'll spend 71 million. And we can see that as opposed to the past, we have a reduced budget, and that is simply because of the implications of the budget cuts. As I move to the second program, which accommodates outcome 2 in terms of increased reach and enhanced awareness, it is important for me to reflect that in this particular program, which focuses on promotional mandate, the Commission for 2024-25 financial year has had some highlights that are important to reflect so that we understand how we came about to then talk about the stakeholder engagements and community outreach activities that we have planned for the financial year. I must indicate that we have basically participated in the African Committee of Experts on Rights and Welfare of the Child, We participated on an observer status, and we've also had national stakeholder engagements with the Minister of Health on foodborne illnesses, Minister of Human Settlements on issues of human settlements, asbestos, and other issues. We have also had engagements with Minister of Water and Sanitation, dealing with issues affecting this particular area, Minister of COGTA, dealing with issues affecting service delivery, and we've also engaged provincially on issues relating to the implementation of the recommendations of the July unrest report in Gauteng and KZN. We've also had some reports that we issued in relation to the display of the old apartheid flag, which relate to the metadata. I must then, Chairperson, indicate that for the financial year, we are saying our focus in this particular program will be number of stakeholder engagements conducted, which is 250. And for number of outreach, we are looking at 200 of those activities. In terms of the budget for this particular program, for 2023-24 financial year, we spent 116 million. And for 2024-25, 116 million was spent. And for 2025-26, we intend to increase this to 121 million. That is also due to the strategic imperative of the Commission to ensure that we expand our reach, and while at the same time making sure that these activities of outreach are really, basically, we're taking the Commission to the people. In terms of the third mandate, which is protection, I'm looking at number of complaints finalized. And in this case, we are looking at completing 1,200 per financial year. And in terms of systemic interventions finalized, we are looking at completing about 80%. If one was to reflect moving from the past in order to look into the future, one would say in this area we have issued investigative reports at Enyobeni Tavern tragedy. This matter has been concluded. We have also issued report on scholar transport. In Northwest, we have also issued an investigative report on RDP housing violations. In Free State, we have also dealt with municipal service delivery inquiry. In Gauteng, we've also addressed hate speech interventions. While in Limpopo, we have dealt with human rights indaba in farming communities. So those are some of the key highlights in this program in the previous financial year. But looking ahead, I must indicate, Chairperson and members of the Portfolio Committee, that this program spent 11 million in 2023-24 financial year. And for 2024-25, which is the year under review, we spent 10 million, and into 2025-26, which is basically the year of this particular APP, we have slightly increased that to 12 million. This is not really much of a movement. Again, this is because of the financial or constraints or the budget cuts. In terms of the last program of the Commission, which has got two outcomes, we have got following indicators, which I will then basically read out in line with the targets. We intend to report on the implementation of the recommendations that would have been generated by the Commission. We consider this to be quite critical as part of our mandate, and we'll also issue State of Human Rights report and Section 184 reports. And lastly, on this particular outcome, we will also be making submissions in terms of human rights related policies. And the last outcome in this area, it will be that of international and regional human rights report, which we will issue for 2025-26 financial year. Again, if one was to look in hindsight, in order to look forward, one would say the last financial year saw the Commission being present on its observer status in monitoring the elections. We have also done the same in terms of schools infrastructure and access to health care facilities, where we have monitored about 164. Similarly, one must also indicate that the Commission has also been actively involved in water rights, which we refer to as the Water Justice Tracker as one of the flagship projects of the Commission. If one was to interpret what these then mean in terms of finances, we would say that in the previous financial year, we had spent 12 million, and for 2025-26 financial year, we have increased this to 15.5 million. And again, we are reflecting that this is really not significant considering the mandate of the Commission. So the budget has not really increased significantly. It remains below the budget line of the Commission pre-budget cuts. As in 2023-24, we were at 223 million, but these amounts have consistently then reduced over the years due to the budget cuts. So overall, in administration, we're spending 71 million for promotion of human rights. 121 million will be spent, 12 million will be spent on protection of human rights, and monitoring of human rights, we're looking at 15.5 million, which is 220 million. And majority of these funds remain the allocation in terms of what we receive from the national fiscus. The assumptions that were followed in the preparation of these budgets, they are there in the presentation. Taking it as read, I will just emphasize that the budget baseline has not increased at a rate that is consistent with increase in CPI and cost of living adjustment. So that in itself results in majority of the budget being allocated to administration or compensation of employees. So 70% of the budget is allocated to compensation of employees, while 30% is then allocated to execution of the mandate in terms of the APP. As I conclude the presentation, Chairperson, I must indicate, as indicated by the Chairperson and the Acting CEO, that the Commission has ratified the optional protocol to the Convention Against Torture, or OPCAT, and this Commission in December was redesignated as a place that will then continue to house the National Preventative Mechanism, or NPM. This mandate, Chairperson, does not necessarily, or rather has not necessarily been fully funded. We can confirm that as we were making projections and engaging on budget bilaterals with National Treasury, our estimates was that in order to really and fully and effectively function, the NPM would require an annual budget of about 10 million, and that would be with about staff in a range of 8 to 10. So this is an area that we indicate that it remains underfunded as much as it is part of the mandate. And linkages in terms of how we align with the Constitution and the NDP, one would indicate that our work is rooted in equality and social justice. Our work is also rooted in access to basic services and inclusive economic growth. So these are the areas that we believe they link us directly to the key priorities of the NDP and also the constitutional mandate of the Republic. Chairperson, I will not necessarily go through the international instruments, taking it as read, but I must then indicate that one of the most emerging and one of the most important areas is the international, it's rather Convention on Child Rights and the Convention on the Rights of Persons with Disability. Not that these are important than others, but it's important to reflect that these mandates also require resources, and at this point they are under-resourced for the Commission to fully execute this particular function. Thank you, Chair.
Thank you very much, CFO. DM.
Chairperson, thank you very much. think just a few very brief points. I think firstly, just also to remind ourselves that the Human Rights Commission is a Chapter 9 institution created in terms of Section 181(1) of the Constitution. 181(3) places a similar obligation on organs of state, as with the judiciary, through legislative and other measures to assist and protect these institutions, to ensure the independence, impartiality, dignity, and effectiveness of these institutions. Section 181(5) also provides that these institutions are accountable to the National Assembly and must report on their activities and the performance of their functions to the Assembly at least once a year. I'll come back to that latter point at the end of my remarks. But just to thank the Commission, led by the Chairperson, Reverend Nissen, I think for the consistent work which they have done in furtherance of their constitutional mandate. And I think that finds expression in a truly activist approach to the work of the Human Rights Commission. It's not a body that has been content to sit in their offices and their boardrooms, deliberating and discussing, much as that is important. They've been active, they've been out in the field, they've tackled some of the most difficult and pressing issues affecting our society at the moment. And I think all of that just underscores the wisdom of the constitutional architecture that we adopted almost 30 years ago. And I think it's underscored also by the challenges faced in many, many parts of the world where we see intrusions, encroachments, violations of human rights, and increases in authoritarianism. And I think the fact that we at the dawn of our democracy realized the wisdom of having this architecture of independent constitutional bodies to safeguard the rights of our contained in our Constitution, I think has borne ample fruit. I think in that role of supporting the Commission, and I think as the Minister indicated earlier, this is an area of responsibility that she has delegated to me. We continue engaging on an ongoing basis with the Commission, firstly with regard to the legislative framework within which the Commission discharges its duties, and in particular, two burning issues. The one is the financial and administrative independence of the Commission. So we are looking at that and looking at how we can amend the legislation to provide greater financial independence for the Commission. The second issue, which is a bit more complex and which is also currently the subject of litigation, is the binding nature of the findings by the Commission. Commission has argued consistently and very strongly that their remedial action, so to speak, should enjoy the same status as that of the public protector. So that is another issue that we continue to engage with the Commission, even as those processes unfold before our courts. Now, I have referred to the activist approach that has been adopted by the Commission, and I think it is demonstrated very clearly in the APP, the strategic plan and the APP that they've tabled, involving both education, creation of awareness, but also actively going out and litigating in favor of individuals and communities. Now, I think just to pause there for a second is that it also bears reminding that the Human Rights Commission Act does provide for the Commission to litigate, And the Commission has established a legal clinic, which is also registered with the Legal Practice Council. The Commission has also referred to the establishment of the National Preventative Mechanism. This is something that was actually done some time ago, but the Human Rights Commission based in Geneva wanted us to formalize that process, and that was taken to Cabinet. Cabinet has now officially designated the Human Rights Commission as the National Preventative Mechanism in the context of the optional protocol against torture. I think it's also worth pointing out that the Human Rights Commission operates and works very closely with a range of other organizations, which would include IPID from the point of view of the police, the medical ombud, the defense ombud, basically all those who work with situations where people are kept in some form of detention or captivity. The inspecting judge of correctional services, of course, plays a very, very important role. Now, the Commission has pointed out quite correctly that this does impose an extra financial and resource liability on them. And after the members have engaged, Chairperson, through you, I'll ask that DDG Shireen Saeed maybe also just talks a little bit more about the steps that we have taken to assist the Commission in dealing with those resource issues. Coming to conclusion, I think one other very important area where the department works with the Commission is in discharging our international treaty obligation reporting obligations. We recently held a very, very productive engagement together with the Deputy Minister of International Relations and Cooperation, Deputy Minister Boertes, and the Human Rights Commission to see how we can, as a country, really expedite both the finalization and improve the quality of our reporting in terms of our international treaty obligations. Chairperson, I conclude by maybe just positing a matter that the committee might want to deliberate upon, maybe not today, but at a later stage, and that is that Section 181(5) of the Constitution specifies that the Chapter 9 institutions account to the National Assembly. And I think the question is, what is the institutional architecture and modalities for the National Assembly to interface with the Chapter 9 institutions and to ensure that the reports that they submit and the matters that they raised are indeed dealt with by the Assembly and channeled appropriately to the relevant structures within the Assembly to make sure that those reports are taken seriously and are acted upon. Because human rights is not a matter that can be reduced to a particular silo. Human rights, by their very nature, are all-embracing and multifaceted. So I think it's correct that the Portfolio Committee on Justice and Constitutional Development is the point of engagement in terms of things like what we're dealing with today, the APP and the strategic plan. But there are so many issues that the Human Rights Commission investigates, engages upon, and reports upon that affect other portfolio committees. And we would want, through you, Chairperson, for the committee maybe to deliberate that on those matters and for those matters to be taken up in the appropriate structures in the Assembly. With that, I thank you very much.
Thank you very much, dear. Members, can we interact with the presentation? Honorable Nomvalo, Honorable Mhlala, Honorable Breitenbach, looks like we have 3 now. Okay, Honorable Nomvalo, please come.
Yeah, thank you very much, Chairperson, once again. Chair, I just want to first engage the aspect that the Deputy Minister is also engaged. The issue of the status of the recommendations of the Human Rights Commission. I think really the current status is detrimental because it's a threat to the credibility and dignity of the Human Rights Commission. It makes it to be an academic institution whose recommendations cannot be implemented. It depends on the institution or a person against whom those recommendations have been tendered. It just depends on their conscience. But there is nothing legally that that gives or that affects enforcement of such recommendations. So I think maybe as part of our responsibility for this financial term, we must consider the strategy of ensuring that the Human Rights Commission enjoys the same status. Maybe we can fight it through litigation or through amending the current legislations. Because the Human Rights Commission is a very important institution, Chapter 9 institution, which has a very critical responsibility to defend and protect the rights of the ordinary people in this country. So if it's just a toothless institution with no recommendations which have a binding effect, then its existence is as good as non-existent. So I think it's very important that we revisit that aspect because it borders on the strength of the institution. So I just wanted to engage that as the first point. Secondly, Chair, when we were doing the oversight in KZN, we just discovered what we already knew at that time, what we called a toxic environment in the human rights offices, I think across. But the experience that we got in Durban made it clear that Durban is the worst of all problems that the Human Rights Commission is currently faced with. Now, what we deposited there in the meeting is that maybe some of these problems are caused by the fact that the commissioners or the Human Rights Commission took a decision to deploy commissioners to provinces with a very vague job description, and which resulted into a situation where there is a power struggle between the provincial managers and the commissioners, because the commissioners would want to exercise powers that ordinarily belong to the provincial managers. Now, we said maybe when we have a meeting with the Human Rights Commission, we just need to have an engagement with them to see and get their view on this in this regard, to get their understanding of the situation. That is that deployment of the commissioners to provincial offices not contributing largely to problems that are faced by the Human Rights Commissions at a provincial level. Thirdly, Chairperson, it goes without saying that if the Human Rights Commission exercises its constitutional obligation to a full extent, then they would require huge amounts of litigation because the human rights are violated every day, everywhere in South Africa. And people are left with no recourse because some do not have monies to fight against such violations. And the coming in of the Human Rights Commission is always very helpful under such circumstances. But my fear, Chair, is that the amount that is allocated for litigation in the Human Rights Commission is not enough, and it precludes the Human Rights Commission from exercising its obligations fully and without any financial hindrances. So I just want them to speak for themselves that ideally, for you to be able to take people who violate human rights to court or for you to subject them to litigation, how much do you think can be fair for the commission to have? Because sometimes you might not be able to take, because litigation is very expensive. You have to employ senior counsels, you have to employ law firms, and so on and so forth. So how much have you done a homework in that regard to say, for us to be able to do this extensively, this is the amount that we would require? And fourthly, have you explored avenues which are going to or in trying to eliminate the toxicity in your offices? Because I think of many challenges that you have, a toxic environment remains our major concern as this committee, because when we did oversight, despite what was presented to us, notwithstanding what you presented to us as the commission, we experienced ourselves the toxicity in the workplace. Now, have you made or have you projected some interventions which might be strategic to eliminate such toxicity in your workplace? Because I can tell you that even now, even yesterday, by the way, we get some complaints directly from some of your employees in your office. And I think you realize that it almost, in fact, it did not even almost, but it damaged the reputation of your office last year, this toxicity. So I think you need to be ahead by now, and you need to be strategic enough to put measures in place that will arrest such. Have you put measures? And if you have done so, then what are those measures that you have put, maybe from an administrative or from a policy perspective? And then lastly, do you have well, I appreciate this one of a law clinic. It's a very strategic intervention. What we can advise is that it must have a proper staff, because we've seen good institutions or good initiatives being destroyed by the lack of professionalism and by lack of capacity, while they have good and strategic objectives and good intentions of representing or of standing for the interest of the poor. Now, so we wish that that office be protected with a proper level and high level of professionalism. It should be protected with the high levels of competency and capacity. But in my view, Chair, in closing, considering the vast of the scope of framework that the Human Rights Commission is engaged with, I really think that the budget is too small. In fact, it represents 10% of the actual work that they should be doing as a commission. We saw it ourselves when you were going to your offices, that in places like Gauteng and KZN, which are very big, with a huge population, they only have one offices. There's only one office, I mean, in Gauteng, there's only one office in KZN, and that means people don't have easy access to offices because they are not accessible geographically. So, but now other institutions, they introduce these online things which are called modern what. So I think also as a human rights, you must also explore that even though it cannot be efficient as we desire it to be, because many people in the deep rural areas don't even have internet. Some have network challenges. There are places, if you know the rural areas in South Africa, there are places where there is no network at all. So the digitalization is not suitable for all citizens. It's only suitable for those who have access to the internet and who have enough resources, because also there is a problem of data, which is very expensive. At least maybe it's suitable for those who have internet in their areas, free internet, but I think in South Africa, those areas are less than 20%. But the deep rural areas are not going to be helped by the online systems and so on. And then lastly, in terms, if you can rate the implementation of your recommendations in the previous financial year, which percentage can you give the implementation? And with those recommendations that have not been implemented, what have you done, or what recourse do you have in terms of the law? If now you give a recommendation to the police department, for instance, and then they don't implement, and they will take advantage, of course, of the current legal position that your reports do not have a binding, or your recommendations rather do not have a binding effect. Now, what recourse do you have? Because I really want this committee, or I really wish that this committee assists this commission, because it is an integral facet of our democracy. It was established to support democracy, so it shouldn't be just an academic committee with no teeth or with no binding effects. And then lastly now, Chairperson, on the issue of extortion, have you ever done a research? Because extortion is very wide in our areas wherein we reside. And the orchestrators of extortion are people who are feared in society, who are very rogue. and people are very scared of reporting them. And even the whistleblowers are scared of reporting them because the whistleblowers are not fully protected by the current legislations. So have you done a research on the extortion saga that we are currently faced with in South Africa? And if so, have you submitted a report maybe to the Minister of Police? And has such report been implemented? Thank you very much, Chairperson.
Honorable Mhlala.
Thanks so much, Chairperson. Let me greet members of the Portfolio Committee and also extend the greetings to the Human Rights Commission and the department as well, ministers and deputy ministers. Thank you, Chairperson, for the opportunity to contribute. Chairperson, I need to raise a serious concern regarding the South African Human Rights Commission. While the Commission consistently produces quality research and well-argued reports, the unfortunate reality is that in most instances, its recommendations are not binding. I think the Deputy Minister spoke about it. Honorable Nombalo as well brought that matter as well. So this renders many of their findings ineffective, as state institution and individual implicated in human rights violation often ignore this recommendation with no consequence. Chairperson, this is a structural weakness in our human rights enforcement regime. It allows for systematic violations, whether in education, in policing, in housing, or service delivery matters, to continue unchecked. Research without enforcement become a hollow exercise. It is not enough to write reports and hold dialogues, while what is needed is implementation, accountability, and direct consequences for failure to act. Chairperson, let me also again join Honorable Nomvalo on the issue of the litigation capacity of the Commission, which always remains very weak. Many communities across the country rely on the South African Human Rights Commission to litigate when their rights are violated. Yet the institution often cites limited resources and budget constraints as a reason for not pursuing cases, particularly those that could challenge state power or entrench injustice. Chairperson, if we are serious about defending the most vulnerable, the Human Rights Commission must be resourced not just to observe, but to act, to litigate, to enforce, and to follow through. Parliament must explore how to strengthen the legal force of its recommendation and ensure that the Commission is adequately funded to carry out its constitutional mandate without fear or favor, Chairperson. Chairperson, we cannot also pretend that a Chapter 9 institution facing a real terms budget decline for 3 consecutive years, from minus 7.79% in 2023-24 to minus 11.06% in 2024-25, and a further minus 2 cut in 2025-26 can still do more with less. Treasury's headline figure of 220.6 million for 2025-2026 is simply not sufficient to match the rising scope of the Commission's responsibilities. Even the additional allocating of 5 million in 2025-26, 8 million in 2026-27, 10 million in 2027-28 are overshadowed by instruction to cut staff from 199 to 186 by 2027-28. That means fewer outreach officers, case workers, and investigators. And for our people, it means more unanswered complaints, more evictions without oversight, and fewer communities reached, Chairperson. Chairperson, the South African human rights internal crisis is well known. Staff in key provincial offices, particularly in Gauteng, where we went for oversight, and KwaZulu-Natal and the Western Cape have long reported toxic work environment, communication breakdowns, and abuse of authority. Yet the strategic plan vaguely calls for an internal environment analysis without presenting a real intervention plan. Worse, there is no dedicated funding, no organizational culture audit, no staff wellness strategy, and no performance indicator to restore institutional cohesion. So my question is, why is there no funded and time-bound plan, Chair, with clear outcomes to address internal dysfunction, stabilize morale, and rebuild the trust of frontline staff who carry the work of this commission? The other point, Chairperson, that I noticed there, in the 2024-2025 APP, the Commission committed to expanding its Human Rights Defenders Program, an essential lifeline for rural and at-risk activists. It also promised a rapid response mechanism to deal with crisis, disaster, political violence, and mass displacement. But you look at the APP now, Chair, both have now vanished from the 2025 and 2026 APP. No mention, no indicators, no budgets. In a country where activists are threatened and communities face routine rights violations during floods and evictions, this silence is just concerning, Chairperson. So my question is, have these programs been discontinued? If not, why are they omitted from the current APP and strategic plan? And how can the Commission justify the removal of crisis response tools during a time of escalating human rights emergencies? The other point, Chairperson, is about the Commission talk of state-of-the-art digital system, including the AI tools, the digital complaints platform, and cybersecurity upgrades. But there's no explanation of what these systems are, how much they cost, or how they will reach people with no electricity, smartphones, or internet access in rural villages and informal settlement. So the 2024 and 25 rollout of the digital complaint system is not accounted for. No uptake data, no impact report, no accessibility analysis. Without inclusive design, digitization becomes a new form of exclusion, not empowerment. So, Chairperson, the question is, can the Commission explain how these digital systems work, how they are funded, and how they will serve people in digitally marginalized areas? And why has there been no investment in offline and how low-tech access tool to complement digital platform? Another point, Chairperson, is on environmental justice without budget or any indicators. Chairperson, the Commission constantly positions itself as a defender of environmental rights. But in this year's APP, no indicator, no program, and no funds are dedicated to environmental justice. There is no support for mining affected communities, no legal outreach in polluted zones, and no provincial monitoring framework for environmental violation. This reduces the right to a clean and healthy environment to rhetoric without follow-through. So the question is, will the Commission amend its APP to include measurable indicators for environmental justice? And what provinces or communities will benefit from such work in 2025, 2026 financial year? Chairperson, once more, this Commission also acknowledges a growing trust deficit, but offers no transparency framework, no public engagement strategy, and no concrete steps to reconnect with communities who feel abandoned. There's nothing in the APP or strategic plan that indicates a systematic effort to rebuild its credibility. So my question is, what internal reflections has the Commission done to address this trust deficit? Where is the plan to engage communities, increase transparency, and restore its standing with a public? Chair, I'm also going to speak on what we call the OPCAT obligation which seems like is being ignored. South Africa has ratified the optional protocol to the Convention Against Torture, the OPCAT, obligating the state to maintain a functioning national preventive mechanism to monitor detention facilities and prevent torture. Here, the APP contains no indicator, no funding, and no operational clarity for the NPM. What is the status of this, of the NPM, Chair? Is it operational and funded? Has the Treasury been engaged? And will a dedicated performance target for detention monitoring be included in the APP? Another issue, Chairperson, I want to commend the South African Human Rights Commission as well for the vital intervention in the Matsilinyana municipality. I think they started, when they started with their the presentation, they mentioned that. So we are very happy and we hope that they will hold other municipalities accountable that are failing or neglecting residents in access to clean, safe water and basic human rights. So their court order compelling the municipality to act, it is a very crucial step in restoring dignity and justice for the people, and it must happen across the country, because it's not the people of Matsilinyana only who doesn't have water. The people in Sikukune, the whole region of Sikukune, they don't have water. People of Vembe, Toyando area, they don't have water. The majority of the people in Free State, they don't have water. Majority of the people living in the Western Cape, I thought when they say Western Cape, it's very bad when you go to these places, the people doesn't have water. We are speaking today, the people in Knysna suffered for 2 weeks or 3 weeks without water. So we need the Human Rights Commission to at least try and assist us in that regards and compel this municipality through court orders to ensure that these things happen. As much as we are more also concerned about the issue of the funds in terms of the litigation, but keep doing that very important job that you are doing to push these authorities to account. Another issue, as I'm about to conclude, Chairperson, there's a matter that we brought, the community of Guguletu brought before the Human Rights Commission of the community that was dispossessed their land. And later that land, they were dispossessed the land in 1995 or 1994. Later that land, a mall was built there. The community never received any form of compensation. Their children are not working in that mall. They went to engage the mall to say that, please give us at least something because you failed to compensate us. You did not do anything. The mall then went through the litigation processes where they were served with orders from the court. So the matter was brought before the Human Rights Commission, but the community seems like it did not get the attention that it deserved in those issues. I don't know whether it's the issue of not having resources in terms of the litigations to assist them at least to be able to fight their rights, as they don't have money to do that themselves, to pay their own law fee, court fees and everything. So we are requesting the Human Rights Commission to intervene in that regard and assist this community, because that is the only place they think that they will get justice in that essence. As I wrap up, Chairperson, I also want to urgently highlight the ongoing sewage crisis devastating Cape Town's Black and Coloured Township. The people of West Bank, where I went to do oversight, the Samora, the Philip, the Nyanga, the Khayelitsha, and beyond, they are experiencing serious problems in terms of sewage. These communities have been neglected under the DA-led municipality, forced to endure raw sewage spilling into their streets and home, creating severe health risk and stripping them of their dignity. Residents face overflowing toilets, blocked drains, and stagnant sewage that attract disease-carrying insects and contaminates their environment. In Inyanga, protests erupted after sanitation services were abruptly stopped, while in Khayelitsha and West Bank, sewer spills flood informal settlement, forcing vulnerable children and elderly to walk through human waste. Samora and Philippi erratic drainage pollutes wetlands and exposes residents to dangerous pathogens like E. coli. So, Chairperson, my question is, how will the Human Rights Commission hold the City of Cape Town accountable, like how they did with Masilunyana, for this ongoing environmental and human rights disaster? What concrete step will the Human Rights Commission take to guarantee that Black and Colored Township receive equitable and dignified sanitation services? And how can the Commission support affected communities in monitoring service delivery and assessing justice? Lastly, Chairperson, is on the matter of Tswetswe. I just want the Commission also to respond on that. What did they do to assist in such a human right violation matter that happened in Eastern Cape, Matatiele area, where a young girl of 7 years by the name of Tswetswe was alleged to be raped? What did the human rights do? What kind of reports do they have? What kind of investigation did they conduct? Thanks so much, Chairperson. I'll pause there.
Chair, you can start with the responses.
Thank you so much, Chairperson. Thank you for the questions and the comments, and thank you for your support. Let me say that I'm going to share the answers between myself and the Secretariat who are here. So thank you to the DM for the words that he spoke about the Human Rights Commission. Honorable Bahar, you raised a number of issues and issues around the toxicity. The others I will ask they will explore. They will assist in this regard. Yeah. So they will assist in this regard. Can you hear me, Chair? Can you hear me?
But I want to check where is your mic, Chair, because when the CFO and Ms. Pillay are speaking, we can audibly hear them, but when it's your turn, it just vanishes. Yeah, you can proceed. Yes, it's better. It's better. It's better. You can proceed.
Thank you so much, Chairperson. The CFO and CEO will assist with the number of questions being asked, but just to say that the first one that our colleague Honorable Mbalo has raised about commissioners in the provinces. The commission took a decision to decamp them out of no longer to be deployed in the provinces as commissioners, and this helped to normalize the relationships. And so there are no more commissioners in the provinces, but that does not prevent the commissioners from doing provincial visits. But that's a normal part of the work and so on. And also provinces can also call the commissioners to assist in, for example, the inquiries and the hearings, etc. So the law clinic, all the provincial offices are dedicated law clinics, and some of our provincial members also go to court and assist complainants. Honorable Moshala, you raised a number of important issues and certainly some suggestions on the issues around the communities that are there facing those difficult circumstances. And also you've asked us to continue with the related to intervention. And yes, you asked us, can we amend an APP? I will ask the Secretariat to respond to that. Chair, on the toxic environment, I think the internal stabilization is there, and I think we'll ask the CEO to respond to that question in terms of the staff and where we are in terms of stabilizing the organization.
Thank you very much, Chairperson of the Commission, and thank you, Chairperson of the Committee, and honourable members for the questions. I suppose between the CFO and myself, we will try our best to provide responses to some of the questions, or to all of the questions that has been raised. I think from my side, I will start with Honourable Nombolo's concerns around the current organizational culture. He referred to the toxic environment that they have identified, or that the committee has identified in the KZN provincial office. And yes, indeed, it is something that we as a Commission, or as the Secretariat specifically, are quite alive to, in terms of making sure that we take the necessary steps to address how it came to be that we found ourselves in this position. We decided in the third quarter of the last financial year that we would take steps to address the so-called toxic environment by firstly assessing what seems to be the root cause of these issues. And we decided to embark on what we called or referred to as an organizational culture reset process, which involved having dialogues with these various staff in provincial offices, and also trying to build a relationship of trust between ourselves and them, so that they would be able to clearly indicate to us what seems to be the problem. And I think one of our issues, as pointed out by the Commissioner, by the Honourable Member, did relate to a sort of overlapping in roles and responsibilities between provincial managers and commissioners. We had to ensure that we did take steps to deal with issues of governance in that respect, and also put in place intervention plans. And as part of the intervention plan, it allowed us to enhance our current governance mechanisms, or our governance processes internally, and also allowed us to put in place a sort of protocol of communication that would assist provincial managers in the manner in which they communicate with the Secretariat, and would assist commissioners in how they communicate amongst the Secretariat itself. And I think that allowed us to foster what we would like to refer to as a culture of accountability amongst ourselves, and also a culture of ethical leadership. Now, we do have intervention plans in place. It's not, this process that we've embarked on was certainly not a process that we expected to resolve the issues that we were facing overnight. It obviously expected us to yield some long-term results. But what we currently have are intervention plans, and these intervention plans are unique to each province depending on the issues that are being faced in each of those provinces. Western Cape, for example, we have a specific plan that the Secretariat will be undertaking. Well, we started last year. We started at the beginning of January to try and intervene and assist in the concerns that we've been raised there. We've already undertaken investigations through the Secretariat in KZN, and of course, commissioners have taken that further in trying to find a most suitable outcome. But like I said, the intervention plans are specific to each province. I think the chairperson also mentioned quite a notable step that we've taken in the commission relating to issues that contributed to this culture, and that is to what we're referring to as redeploy or decamp commissioners out of the provinces. So currently what we have is commissioners that have national focus areas and not necessarily operating within or from provincial offices. So we are in the process of also developing our very own service delivery model that will assist both the Secretariat and commissioners in understanding how this would have a practical impact on the ground to ensure that I referred to earlier, there's boundaries between strategic oversight coming through from commissioners and also the actual operational delivery that's meant to come through from members of the Secretariat. I'm going to reiterate, Chairperson, by saying this is not a short-term solution to our problems in terms of the fact that we do see this being rolled out throughout this financial year, but at the same time zoning in on what we see as some of the most urgent areas that require attention, or most urgent provincial offices that require attention. Myself, the CFO, and the current acting COO have actually decided to ensure ourselves the implementation of these intervention plans. We've also tried to strengthen, as I've indicated, internal governance protocols by ensuring adherence to governance principles and understanding what roles and responsibilities are, or clearly delineating roles and responsibilities between the Secretariat and the Commission. And we are optimistic that that is going to take us along. I think one of the issues that may have also contributed to, the cultural, organizational culture issue that we are facing is just the lack of internal controls that we had in the institution, internal controls relating to not just operational governance, but also financial governance. And we've also taken steps to ensure that those financial controls or those internal controls were monitored, they were tightened, and that all of our staff that required the necessary training and skills development undertook those trainings and skills development in order to contribute to the effectiveness and efficiencies of these measures that we were taking. And as far as the issue of litigation is concerned, perhaps I can touch on that as well. Yes. While the Commission does have the mandate to litigate, litigation is quite costly. And we more often than not find ourselves having to take steps through strategic litigation in order to compel specific stakeholders to comply with the directives of the Commission. And I think what we've also tried to do just of late is to, in order to limit the cost of litigation, is just to try and build relationships and also try and implement alternative dispute mechanism processes where we find that those may be helpful However, there are some instances where, in order to ensure appropriate redress for the violation of rights, it becomes impossible for us to do that. And we find ourselves in a position of having to litigate. And sometimes you will find the litigation comes more specifically to the process of investigation after a report has been issued, but then, or after an inquiry has been undertaken, but there's just no responsiveness coming through from the relevant stakeholders. What we've also tried to do to assist the Commission with the high costs of litigation is to put together a panel of legal experts to assist the Commission with its litigation costs, but also ensuring that we have the appropriate level of representation coming through from our legal representatives. We are still in that process. We have incurred some procurement challenges in terms of putting those panels together, but we are moving closer towards finalizing our panel of legal experts, just more specifically to assist us. And that's one of the ways in which we are exploring alternative measures to assist us in that regard. And as far as implementation of recommendations are concerned, yes, perhaps I also touched on it with the issues relating to litigation, but that definitely does appear to be one of the biggest areas of concern in the Commission. And again, related to just non-responsiveness coming through from relevant stakeholders. While we try to build relationships, at the same time, we monitor through our own monitoring, internal monitoring systems to assess the level of compliance with our recommendations. And unfortunately, I'd have to report in this meeting, Chairperson, that while I don't have an actual percentage, and we will obtain it for the committee and share it with the committee, but I was saying, unfortunately, the level of implementation of our recommendations are not very high at the moment. And I think one of the contributing factors to that would be the most recent court judgments. Now, while this has been happening over a number of years, I think more recently, we do find a level of resistance coming through from government stakeholders, referring mainly to these court judgments, saying that that due to the non-binding nature of our recommendations, they don't necessarily have to comply. They're not compelled to comply, and that's due to our lack of enforcement measures. And that's through legislation, we would have to address that. But of course, we do know that legislative reform does take a quite lengthy amount of time. We are hoping that now in the Constitutional Court, in the Agri-Data case, quite strongly addresses this matter and the impact that it has on the work of the Commission, because it certainly does have an impact on the manner in which we execute our mandate, but also what we require in response and as far as accountability is concerned. I wanted to speak a little bit about the status of the NPM and of course our monitoring mechanism in as far as the NPM, the National Preventative Mechanism is concerned. Yes, it is operational. We have been designated, so we have taken steps internally to ensure that we comply with our mandate. What we have done currently is, you would have heard the CFO mentioning the amount of funding that is required, and also the amount of warm bodies that is required. Internally, what we do have is research monitors within the unit, but we are also using our monitors in the provincial office to assist us to ensure that that monitoring mandate is still being executed. So it's not at a standstill. We are taking the necessary steps with the capacity that we do have to ensure that we are able to still fulfill our responsibilities in terms of this mandate. However, in the long term, we will be approaching National Treasury to assist us with additional funding as far as capacity is concerned. both financially and through our own bodies as well. Perhaps I could touch a little bit on the chair's whispering in my ear. Did I miss something? I know I missed a few things.
Pause a little bit.
Yes.
Yeah, because commissioners are online.
Oh, okay. The chair is reminding me, I wanted to talk about the Twitter matter and how we have collaborated with CRL and CGE to look at the criminal justice system in a much more holistic way, but I can touch on that a little bit later. Chairperson of the committee, the chair is reminding me that there are commissioners online, and perhaps if commissioners online and also our acting COO online would like to come in on some of the areas that I may not have touched on thus far, the chair would like to give them an opportunity to do so. Please, Chairperson.
Yes, Chairperson, with your permission, because a number of environmental issues and water and sanitation issues have been raised, and we have commissioners that have dedicated focal areas, and there has been done a lot of work in that regard. So, for example, Commissioner Bosso, on water and sanitation, justice, Commissioner Finana, environmental, Commissioner Tuli, and also Commissioner Ngumbele would engage with a number of issues. And Makasha has been dealing with mining. So there are commissioners there that can, if they can wish to come in, if you allow me to give them opportunity to briefly come in. And Commissioner Mandringosi, with equality.
That's granted.
Thank you so much, Chairperson. Do I start with? Commissioner Bossop, can you come in on the water and sanitation?
Thank you, Chairperson, and greetings to the Chairperson of the Portfolio Committee and the honourable members. Chair, firstly, I think I should start by indicating that the initial contribution that was made by the Deputy Minister on,
Commissioner Bossop?
Yes, Chair.
Commissioner Bossop?
Yes, Chair.
Just switch off your video for better connectivity.
Of course.
Just switch off your video for better connectivity.
Will do. Will do. Thank you, Chair. Right. The initial contribution that was made by the Deputy Minister on reports that also need to be tabled in other committees of the National Assembly, we agree with that, and we have been implementing that approach. A number of commissioners have presented reports to committees of the National Assembly in the previous financial year. I specifically have presented to the Water and Sanitation Portfolio Committee, and I know that Commissioner Makwasha and Commissioner Ntuli have also and Commissioner Gungubele have also presented to portfolio committees in the National Assembly. But when it comes to water and sanitation, Honourable Chair and Honourable Members, you'll agree with me that we are dealing with we need the assistance of two other spheres of government as well, and that being provincial government and local government. And we have managed to have this wonderful working relationship with the relevant select committee in the National Council of Provinces as well. And the Select Committee on Cooperative Governance visited the Free State Province about 2 months ago. The Human Rights Commission was invited to also make presentations, and the purpose of that visit was to follow up on the findings and recommendations of the Human Rights Commission. Now, what is even more encouraging, and we were talking about the implementation of recommendations, etc., that specific select committee is also assisting the Commission in ensuring the implementation of recommendations. Tomorrow, the MEC for Cooperative Governance in the Free State Province will present to the Select Committee on the implementation of the Human Rights Commission recommendations affecting 3 local municipalities in the Free State Province. On the 22nd of July, we have been invited to continue making presentations to the Select Committee on the work that we have done, and where we are also experiencing challenges, specifically with some local municipalities and provincial governments. Now, Honorable Mohlala is 100% correct. There are water and sanitation challenges all over the country. And we as the Commission, although we are doing everything in our power by meeting with the Minister for Water and Sanitation, meeting with the Minister for Cooperative Governance, with provincial legislatures. We have had meetings with numerous provincial legislatures on the challenges, water and sanitation challenges facing provinces and local municipalities. We also, need the assistance of legislative structures, our national legislature, as well as our provincial legislatures, to also assist us in ensuring that our recommendations get implemented. The acting CEO has referred to the legal panel. We will continue, if funds permit, to continue litigating against municipalities. We have identified in all the provinces municipalities where litigation might be undertaken. Lastly, just on water provision, Honourable Chairperson and Honourable Members, the Honourable Minister for Water and Sanitation recently indicated that bulk water supply in the country is not a problem. There is sufficient dams and reservoirs, etc., to provide water to all communities in South Africa. The problem, however, Honourable Members, remains the final provision of water to the communities, the reticulation, the water that comes out of the taps. That is where the main challenge is. And unfortunately, that service is currently being provided by municipalities. So that is the challenge. We have continuous interaction with municipalities, and as someone on the platform earlier said, we are indeed activist commissioners who are on the ground and who are seeking to address all these water and sanitation challenges in the country. I thank you, Chairperson.
Thank you. Chair, who was the next commissioner?
Commissioner Gumbele.
No, thank you very much.
The
Thank you very much, Chair. Good morning, Honorable Chair, honorable members, fellow commissioners, Deputy Minister in the Department of Justice, the staff members. Chair, just a few things, Chair, that I will touch base from my side. One, Chair, is to respond on the issues that Honorable Mvalo have just raised that might be just not related to my focal areas. Honorable Member, I'm serving in one committee that is called Organizational Redesign. One of those committees, just to issue of the toxic environment, what are the measures we're taking, what are we doing, the kind of interventions. So a committee, one of the things that we recommended, you spoke about the issue of brand, reputation of the institution. So we have recommended in the secretariat that there must be a brand management specialist that just to deal with the image and reputation of the institution, because I think it's suffered, rightly fully so, as we indicated last year. We've gone through a difficult time. So that's one of the things that we do. And also we have also recommended the issue of the wellness, of the staff wellness in the institution. So I'm sure those things are in the pipeline. So when we come back, kind of the platform, those are the issues will be reported to by the Secretariat, by the commissioners as well. Maybe Honorable Musala, just to respond to the issues you've raised quite a number of issues, in particular on the issue of the Western Cape, just to focus maybe on this Western Cape province. You know what we have done, we have just, you are correct, most of the poor communities are really suffering when it comes to the issue of service delivery. So one of the initiatives that we have taken, we received a complaint of the entire community, village, we may call it. It's a very big one in the Philippines, informal settlement. So when we went and I've engaged the city of Cape Town, they said that they cannot provide services in that particular land because it's a private-owned land. And then we took an initiative as a commission to have a panel of experts. I think I've invited Commissioner Boshoff on it, and they give us a legal opinion on the matter. And of course, the white paper also says the same thing, that there's nothing stopping the municipality to provide services, even if it's a private land, in particular the basic services. So we have taken the municipality on, and the services on that committee has been provided, but now they are providing outside where the settlement is. So that's where myself and Commissioner Madlungos have indicated, we have visited once again, monitored the area. So it's kind of work that we are doing with the city of Cape Town. And of course, if there's no joy in terms of the providing the service within the settlement, then that's where we think the legal subcommittee, then we can start talking about the issue of litigation. But we are taking them on in terms of service delivery, in particular the poor areas. We are doing monitoring in the city of Cape Town through the Commissioner Makwasha delegation. They have sent a complaint via us in the province. We went to the COVID-19, where there's no services, but we can safely say that our intervention, there's kind of work taking place in the particular area. Water is provided, but might not be sufficient. So that's the work that we're doing in the poor communities of the Western Cape and other areas that we've visited in Mitchell's Plains, such kind of similar things. The issue that also raised, Honorable Member, the issue of the environment rights, climate justice matter, it's a very important matter. I think the country is facing many challenges when it comes to disasters, climate change, and climate justice. So what we did, it's a new focal area in the Commission, climate justice that we did. So we just established last year, but a strategical intervention that we've done so far is to have a panel of experts that have to, so that when we have to deal and respond on issues of climate justice, that the Commission can have a strategic intervention. So what we did in that committee with academia, with also ordinary citizens, like one Mama Makanzi is from the Limpopo. We have also civil society structures, but also important of young people, so that when we deal, we can deal with the holistic responses on the issue of climate justice. So one of the key interventions we'll be doing on the issue of climate justice as a commission-led intervention is the issue we've received many complaints in terms of the pollution, ocean pollution, ocean economy matter. So there's a kind of intervention we are doing that because there's mining taking place in the ocean, and majority of the ordinary citizens are kicked out, or the small scale fisheries are not benefiting on it. Big business are benefiting it, but at the end it pollutes the ocean and the environment. So that's kind of intervention we are doing. Recently, we are going tomorrow on the Northern Cape. We are also having stakeholder engagement on the issue of the mining and the issue of the pollution that are taking place in that particular area. Maybe the question we have raised, but it must reflect on our APP, it must reflect on the work that we are doing. And so that's kind of work we've done. Also in the Eastern Cape, we've done similar work in the East London, where we are dealing with the environment. So I thought let me start space on that one. Maybe in closing, is to say that we have mentioned, fortunately it is my hometown, where there was a struggle of water for a couple of weeks and many weeks. We've produced a report as the Commission in the Western Cape. So maybe that report will be just shared with the commissioners. On a the report comes with the recommendations, what steps must be taken in that particular municipality. That also, it's not just only water, it's the issue of waste management, the issue of water meters. Recently was in Stellenbosch yesterday, there was issue of water meters, and the water meters are systematic. They're only being put on the poor communities. So we want to understand next week meeting that will have the municipality, what process was followed, what the public participation was followed to have to have the program of water meters. So there's other kind of issues that we do. Maybe in closing, Chair, is to say maybe the Commission is really trying to stabilize the situation in the Commission working day and night. Ourselves want to see a functioning and working commission. So we will task ourselves, my Queen Anna, to produce, to go to KZN, produce a report. Indeed, we have produced a report. The report is available. We have shared with all the commissioners. We've been shared to all of the affected people. And those, Chair, thank you very much, honorable members. Thank you, honorable Chair. And thank you, Chair Nissan, for affording me this opportunity just to share the work that we are doing in the province of the Western Cape, but in broader and other focal areas.
Chair, who's there? Who's another commissioner?
Commissioner Makasha, Chairperson.
Thank you so much to the Chair of the Human Rights Commission. And once again, good afternoon to members of the honorable members of the Portfolio Committee. Honorable Chairperson of the committee, let me just start by highlighting some of the issues that are raised by both Commissioner Boshoff and Commissioner Gungubeli. I think it's important when we speak about the implementation of the Human Rights Commission. Often it is laid at the doors of local municipalities, and often, I think this was raised in my recent meeting with the MEC of COCTA, who then alluded to the fact that only 9% of the budget is allocated to local municipalities. And often local municipalities are then given the responsibility of revenue collection through municipal bills in respect of water and electricity. However, given the current economic situation in South Africa, due to the high levels of unemployment and poverty, this has an adverse impact on local municipalities, therefore resulting in poor service delivery. And I think the discussions commissioners are having at a provincial level provide political intervention to ensure that our reports start being implemented at the provincial legislature. And I think the Free State is an exceptional example of how this has been done to ensure that these reports are tabled provincially. And when there is no implementation thereof, it then gets escalated to the national processes. I think it's important when we speak about implementation, we also speak about the budget. We are, as the Commission, envisioning having a budget conference late this year to reflect on a pro-human rights budget process, which is reflective of the realities of South Africa. We do also then have, we do comment on the budget processes, but also always remind municipalities and mayors when they do the ID process to also have a pro-human rights budgeting lens. And often the response that we receive is that they are doing the best they can do with the little that they have. But then goes to, I think, something that Honorable Muvalo said regarding the financial limitations that the Human Rights Commission is facing. We would love to do so much that we have planned and deliberated on as commissioners. However, due to the financial limitations, we often have to be selective of which processes we adhere to, which inquiries do we hold, and that has an adverse impact on South Africans. Therefore, I think the continuous limitation of the human rights budget has an adverse impact on South Africans who often rely on the Commission as a source of human rights defense. In respect of the environmental issues, the Human Rights Commission has partnered up with the African National Institution of Human Rights, as well as the Business and Human Rights Resource Center, and this is to hold a corporate project. This is called Corporate Accountability, Resilience and Participation for an Equitable Transition Project that speaks to environment, the role of business in the environmental issues as well as issues of land. We will be hosting the first leg of this project on the 24th and 25th of June. This discussion is about empowering human rights defenders with the necessary knowledge on when they are faced with slap litigation, how do they proceed, but how do we also get the state and business on board to ensure that when we speak about the Just Transition Project, how does it look like? This means that human rights defenders, civil society, lawyers, and national human rights institutions will then be empowered on how to ensure that holders are more effectively engaged with, hold accountable government and companies. And we've seen that we really need to have this conversation. And because of the financial constraints, we're quite excited that this is not a process that needs to be budgeted by the Commission. It's fully funded by GANRI and NANRI to ensure that the Human Rights Commission is able to have that. This would also then, we are engaging with the human rights defenders on the ground from various corners of South Africa, rural and informal settlements, as well as those who are living in urban areas. This also speaks about the way that the Commission has changed its position, that we really need to speak to those who are living in the most rural areas of South Africa to ensure that they are empowered with the necessary information to hold government and state-owned companies and other companies accountable. I think that in respect of the question of the research into extortion, the Human Rights Commission has developed a new focal area called Business and Human Rights. Over the last year, we have been working with various stakeholders to speak about corruption and how corruption affects human rights. Extortion would form part of that, and extortion would form not only in terms of monetary extortion, but also other types of extortion. We've also seen sexual extortion of females, which is the term referred to for sex to job. So we are working in that. We have had a recent conference where we spoke with the relevant stakeholder, I'm just looking for the name, where we had a conference and we have a Hive document regarding the protection of whistleblowers. As you've seen, honorable members and those who are viewing, is that over the recent years, we have a notable deaths of whistleblowers and no proper protection from government regarding that. So we are working in respect of that. We are working in respect of how corruption affects human rights, and therefore we are pushing for an anti-corruption process to ensure that human rights are adhered to. I think that is important. I think other commissioners have spoken to the issues of how we are working towards stabilizing the commission internally in respect of the toxic work environment, how we are working in respect of policy development, as well as ensuring that relationships are better dealt with. But I think that I would also then hand over to the chairperson of the commission and thank him for allowing me to have my inputs on these particular issues. Thank you.
Thank you so much. Honorable Chair, how do we look for
Yes.
time? Honorable
We
Chair?
are late on time, Chair. Can we wrap up?
Yeah. Can I just ask the CFO on the financial issues? Budgeting. Okay.
Thank you, Chair. I will attend to the budget decline and then kind of cascade that to how it affects other areas. During the presentation, as part of the closing on resource allocation, there are 2 points that I made. One point was that the current budget split is such that we have had to cap it for compensation of employees at 70%, while allocating the remainder, which is 30%, to service delivery activities or programmatic activities, which would be goods and services. Chair and honorable members, you would also recognize that from different speakers, the issue of the undercapacitation or underfunding for the commission has kept on coming to the fore. And the point here is our current financial analysis, if we were to basically go back in time before the budget cuts, our projections indicate that the commission at this point, and I'm not even talking about making significant changes, but just on the current trajectory, the commission is already in a deficit of about 18 million. The only real reason that the Commission is now looking like it is presenting an APP that is supported by a balanced budget is simply because we have had to make a decision that we will cap spending on compensation of employees at 70%, while the rest goes to programmatic activities. It's quite untenable. And if we were to practically then say, what does this make, or what is the financial outlook of the Commission? Without a doubt, one would have to say that the Commission is technically insolvent, because if you were to look generally at the actual cost of servicing its compensation of employees, it would come in a region of about 172 million up to 180 million. Yet we are talking of a budget that is below 220 million. If we factor in the contractual obligations that we have, and we then factor in the expectations that we have in terms of the Act, but also in terms of the informal mandate, we will agree that that means the Commission is in a state where it cannot fulfill all its obligations. The Commission, just like all other institutions, serves a population of about 63 million. Its staff complement is only 201, and its budget is less than 220 million. So with that in mind, that means not only is the Commission underfunded, but its resources are quite stretched in terms of meeting or fulfilling this constitutional obligation. Chair, as I indicated, that I will then cascade this response down to respond to some of the issues that have been raised. There's been a question of the previous strategy having reflected that the Commission sees rapid response and expansion of reach as its key priority. And that is correct. It is only that part of this, or giving effect to this strategic imperative, we have since realized that we are not necessarily saying we are omitting it from the strategy and the APP, but as opposed to making a target that we may not necessarily be able to fulfill, we then focused on community outreach and other stakeholder engagement as things that would drive the work of the Commission to give effect to rapid response and expansion at strategic imperative. But I must indicate, Chair, that given the limited resources that we have, that is why when we talk of digitalization, the Commission has two apps that are currently under development. One is the complaints handling software or application, which will then assist the Commission, in particular communities that may not be able to have direct reach to the offices of the Commission. They will be able to log or lodge complaint over the app. But we must acknowledge that given the limited resources, there will be ongoing engagements that would have to take place between the Commission and the network providers to see if a bill back option or some form of free access to this could be explored. But that is work that needs to be undertaken. We are spending not more than 2 million on that app. In terms of development, it's about 1.5 million. And in terms of the app that is also being developed for purposes of giving effect to NPM mandate, that app also, it will also assist human rights defenders from various locations to be able to update status of the monitoring processes. We believe that through these applications, the Commission will be able to expand its reach, but also improve accessibility. The Commission remains quite worried about the fact that not everybody has access to internet and data. To this effect, Chair, in our engagements with National Treasury, we had requested that National Treasury advances a reasonable amount of money ranging to about 10 million, where we wanted to pilot mobile clinics so that in remote locations where the Commission cannot be found, these mobile clinics can then be moved into those locations, or we can undertake outreach programs where we are taking the Commission to the people. These initiatives are not necessarily forgotten. The Commission recognizes that these are quite important, but we also appreciate the fact that we do not have enough resources. We only have about 2 million, which was part of the engagements with Treasury, that has been set aside for this particular initiative so that we can pilot it. In the previous market review process or analysis that has been done with supply chain, it revealed that in order to have this truck modeled in a right way, we might need an average of 3 million. So these are some of the things that we are really working on, and we are assuring and reassuring the committee that it does not mean this has been abandoned, but we are making sure that our APP and our strategy reflect the imperatives or priorities that can actually be met. Similarly, Chair, with your permission, I would like to then also just in rounding up my answers, indicate that indeed, Chair, the issue of toxicity is a matter that the Commission takes very seriously. And as colleagues and commissioners have indicated, the Commission has not only decided to decamp commissioners from provinces. There's a commitment currently to develop a service delivery model which will assist the Commission not only to define how it renders its services to the people of South Africa, but this model will also assist in delineating responsibilities and roles between the Secretariat and commissioners, between the Secretariat and executives of the provinces. So this model, once finalized, it will assist in responding to issues of toxicity. But we do not see that this will work in isolation. Similarly, the commissioners have adopted committees or governance committees, which will become formal structures that are supported by clear terms of reference, which will then guide how these committees execute their work while exercising oversight. I must also indicate that the Commission, despite or rather in addition to adoption of the staff wellness policy, the Commission is currently working on finalizing staff retention and succession policy. We believe that if there is leadership stability in the Commission, that will also assist in improving stability. On this very point, Chair, I must indicate that targeted management development program has also been identified as quite important to make sure that managers are trained in such a way that not only are they able to fulfill the mandate of the Commission, but in how we deal with the day-to-day activities, we are all up to date with the current practices. The disciplinary policy and procedure is one of the policies that we are currently reviewing with a view that sometime in August, we should be able to have a policy that will assist the Commission to manage or respond to some of its current challenges. Without a doubt, none of this is a silver bullet to resolving the issue of toxicity. It will require collaboration on the part of commissioners, on the part of the Secretariat, and on the part of staff in general. And in this regard, Chairperson, I should leave my submission in terms of responding to the answers here with a belief that should the committee require written responses, given that there is extensive input that has been provided, we will certainly be able to do that and submit that to yourselves. Thank you, Chair.
Thank you, CFO. Chairperson, thank you, CFO. Chairperson. Honorable Chair.
Yes, Chair. Are you done now?
Yeah, we're done, Chair.
Chairperson.
Chair, can you hear me?
Chairperson,
Thank you very much, sir.
Before
Thank
we
you very
wrap
much,
up,
sir.
may I please just do a follow-up question?
No, was still
Hello?
giving the DM.
Before the DM, I think
Was
after
still
the
giving.
DM. Or
Sure.
must I allow the DM to speak first?
We
Hello?
can't hear you, Honorable Mhlala. You can come, but we can't hear you. We can't
Okay,
hear you properly, but you can come.
All right. Let me allow the DM because I'm driving, but I'll be arriving soon, and then I will come after the DM. Thank you so much.
DM, can you do the parting shots?
Yeah, Chairperson, thank you very, very much. I think we've had a very, very full and detailed engagement for which, from the side of the executive, we would like to thank both the Commission as well as the Portfolio Committee. I think just 4 very brief points. The first is that the matters raised both by the Commission and the Portfolio Committee regarding the budget, we hear them and we are in support of that. We would hope that these matters and the resource constraints faced by the Commission would feature prominently in the committee's report, because I think that would also enable us to assist the Commission in their engagements with Treasury to negotiate for more resources for their important work. Secondly, the issue of whistleblower protection and the anti-corruption architecture was mentioned by a number of speakers today. I don't think this is the time or the place to go into details, but I do think that we have indicated that the department is busy working on whistleblower protection, and also that it has been assigned responsibility to process the recommendations of the National Council, the National Advisory Council Against Corruption, with regard to proposals on an anti-corruption architecture. Thirdly, the National Preventative Mechanism, just to give the assurance that indeed it is formally established. I had hoped that there would be time for DDG Said to say something about the budget, but I do think we've run out of tarmac, and I think the matters have also been quite adequately responded to by the Commission. Just lastly, Chairperson, to return to the point that we had concluded our introduction on, is that we would really value the input of the committee with regard to the role of the National Assembly. It's something that we also intend to take up with the presiding officers. I know that many years ago, when I was Deputy Chief Whip of the ANC and House Chair of the National Assembly, there was a Chapter 9 office within the Office of the Speaker. I'm not sure what has become of that, but we certainly intend to engage the Speaker on that matter. But thank you very much for a most productive engagement. Thank you.
Thank you very much. Honorable Mhlala.
No, thanks so much, Chairperson. I think the Deputy Minister have covered me because he touched on the budget matter. Because listening on the presentation and the response from the commissioners from Human Rights Commission, you can see that there is serious issues that will impact the Commission if we don't expand the budget allocation to the South African Human Rights Commission. Chair, the Commission is doing a critical work in monitoring human rights violations. So producing evidence-based research and engaging communities on the ground. So we are requesting that through the cabinet and also, through the cabinet please go and speak on behalf of the Portfolio Committee and also on the Commission to expand the budget. I think it's been 3 times in a row now the budget is being reduced every now and then. So let's make justice to them and give them a budget. Lastly, Chairperson, I forgot when I was asking questions. They also raised the issue of sourcing funds from international countries and all those things. They did not disclose who are those international countries that they are sourcing funds from. Is it possible for them to disclose for us? Because we don't want ourselves taking money from various financial institutions. At the end of the day, we find ourselves having a commission that is highly compromised, not be able to do its job. So if possible, can they please disclose in that regard? Thanks so much.
Thank you, Honorable Mhlala. Thank you very much, colleagues. Colleagues, I think let me just say some few quick things that I think would have been central in the discussion in this meeting today. The first is the issue relating to commissioners being taken off provinces, and I think we need to further speak on it, because I don't want it to receive some misconceptions, because this would have been some of our own observations as the committee when we decided to take an oversight tour to provinces after having received a lot of complaints about which we regard as a toxic environment. There is no doubt from ourselves that it would have been, the commission would have had good intentions when they would have deployed commissioners to provinces to enhance accessibility, to enhance visibility, to be hands-on on issues on the ground. The committee doesn't doubt that that would have been an intention. But from our assessment, having went to the provincial offices and including the national office, it was vivid to us that actually the intended intention, the intended purpose, actually we received unintended consequences of what would have been an approach to enhance accessibility and visibility. And there is no doubt that when the commission is ready again to partake in that work, after having assessed the situation, after having been able to eradicate completely the current toxic work environment, it would have been ideal to have ways of ensuring that the commission is accessible and more much visible. So we welcome the withdrawal of the commissioners from provinces. In the entities that report to our portfolio, Human Rights Commission is the second youngest in terms of budget. The youngest being the information regulator. And there's no doubt that for a rapid and an aggressive human rights protection, you need more much budget than what you have, which is slightly above 200 million. In all our interactions would have made concessions that it becomes practically impossible to extend to every corner or every portion of society with the current resource that we have. So we've got, there is a proposal that we should make a consideration to the fact that we can request a meeting with the Appropriations Committee to argue for a better budget, even if it's for the medium-term framework. So we're going to arrive at that determination when we're done with the budget vote, so that we don't go in snippets. We consolidate all the budget needs that our portfolio has, cutting across all the entities that are actually reporting to our portfolio committee. So that our argument must be one and solid, and it must reflect all our budgetary needs in terms of or every entity that would be in need of an extra budget. Look, there is no doubt apologies about that. So, look, the issue whether or not there is a toxic work environment is no longer a discussion. I hear the acting CEO say, calling it the so-called toxic. It's no longer the so-called toxic environment now. We have all come to that determination that after having assessed the situation across provinces and in the national office, would have picked up that there is a link, there is an interrelation to what is happening in the national office, what is happening in the Western Cape Provincial Office, what is happening in the KwaZulu-Natal Provincial Office. So it's no longer an issue about arguing whether the environment is toxic or not. Even the survey you have commissioned yourself as a commission actually suggests that the working environment in the South African Human Rights Commission is not conducive. So it's no longer a matter of a discussion. But what we will request, Chair Nissen, from you is that, because you say you have got an intervention strategy or an intervention plan, but this intervention plan is not standard. It is informed by inner battles or circumstances in that particular provincial office. So I would request that you share with the committee the intervention plan or the intervention strategy, because we would understand that this would have been our central point, our central departure point on exercising aggressive or robust oversight over the commission. So we'd like to be updated every now and then on how far have we gone, because our belief is that the reason why the commission has been the worst performing entity in the entities that report within our portfolio committee is because of the soldiers that are there in the camps are not combat ready to go to this war that we are paying them to go to. So if this is not fixed, if this is not attended to, it therefore means we'll have a persistent problem of a toxic work environment and all that. Members would have asked here about wellness programs to boost the staff morale. So would like the commission to share with us the intervention plan, which is informed by circumstances in each and every provincial office. Look, we are all in agreement, and we have always, DM, as the committee, all of us, have always had concern about the enforceability of the recommendations of the Human Rights Commission, and would have advised at some in numerous occasions that maybe the best way is to go this way. They would have updated us that they went to court at some point. The matter was due to go to the Concord, I think, beginning this year or end last year. But I think it is true that that can be the only intervention, because part of what we're making a reference on was how the Public Protector South Africa was able to get their recommendations enforceable. So that's part of the considerations that were, amongst others, that we're considering. But I think, as you say, DM, it's time that we also play a central role in ensuring that we bring back, or rather we install, proper teeth for the commission. Otherwise, it will be toothless, no one will take it serious. It will be as good as non-existent. It will make recommendations and nothing will happen. It will make recommendations against a municipality and the same wrongdoing will happen and no one will do anything. So always taking those recommendations to court is quite costly, as we all agree. But I think let me bring your attention to Section 6 of the South African Human Rights Commission Act, which obligates the commission to go to the president or parliament to present on any matter that relates to the exercise of their obligations. So, Chairman, I want to give you as the commission a homework that you go look into the South African Human Rights Commission Act and make a proposal to Parliament on what amendments do you think that are necessary to strengthen the recommendations of the Commission. Could be appreciated if that can be done in the period of 6 months. Also update us through writing when you give us the intervention plan on this issue on Mhlala is raising of an external funding. How do you go about and all the issues related to that? So I think that's one of the strategies or strategic interventions that we must make in respect of the recommendations, the enforceability of the recommendations or the status of the recommendation. So let's take that homework, Chair. You use your research capacities. You even benchmark in other countries on how strong are the similar institutions in other countries. You make just a research paper on it. You make recommendations on it. You present it to Parliament. Would have no issue to make it a committee bill. Let's just do that, Chair. Members, thank you very much for the proper interventions on both the presentations from OCJ and the South African Human Rights Commission, the Minister and the Deputy Minister. I think we appreciate, DM, the fact that you commit ourselves to come and be answerable to Parliament in respect of anything. Even at the time when we did not strictly request that you attend, you see it upon yourselves as an obligation to come and account. I think we note that as the committee and we appreciate it. The Commission Chair, Nissen, and the Commissioners and the Secretariat of the Commission, we thank you very much. We see that although it may not be a huge improvement, but we see that at least there is something that is being done. You'll remember the good words of Honorable Matafa, that our support to any entity that reports to us is conditional. We support you because we see that there is effort you are putting in ensuring that you are able to improve the situation. You sit down and do nothing, we are going to be on your back. You will feel that we hate you when we don't. So I think from where we are seated, we are seeing a slight improvement. We just need to focus to ensure that in the next financial year, the performance of the Commission is much better than it is today. Colleagues, thank you very much. The meeting is adjourned.
Thank you very much.
Chairperson. Thank you, DM.
Thank you, Chair.
Thank you, Commissioners.
Recording stopped.
Thank you.